Good morning. Welcome to the Michigan Court of Appeals on behalf of myself, Judge Borello, and Judge Ledica. This is panel 3 for the December 2025 case call session. I can't think of an arrangement that makes it more obvious that the determination of who presides is random and not based on judicial tenure. We've read your briefs and other submissions and are well acquainted with each of the cases. You do not need to rehash the facts or the applicable law. Oral argument is an opportunity to highlight something beyond what is in your brief or to clarify any point that may not have been as clear as you intended. By court rule, each party is allowed a total of 30 minutes for argument if opposed, or 15 minutes if only one side is endorsed. We do not anticipate that any of you will need the full allotment of time this morning. If you plan to divide your argument time with another endorsed party, please advise us of that at the outset. If your clients are present, please inform us so we may also welcome them to the court. Because arguments are recorded and published publicly on YouTube, we caution counsel not to mention the name or location of any minors or other vulnerable people. We will now call item number 1, docket number 373642, People v. Shaft. And I believe the appellant's attorney has waived oral argument.
Yes, I did receive that email over the weekend. Good morning, Your Honors. Monica Wilson is.
Really? When did that happen?
It says that on our sheets.
I think Saturday I received something through True Filing that Mr. Roach was waiving.
Well, good thing I got all these questions for him. I should read my email. Next year.
Monica Wilson, Assistant Attorney General on behalf of the people, Your Honors. This matter, I believe, was pretty thoroughly briefed by both sides. And in light of Mr. Roach's waiver, I would just take any questions that the panel has.
Go ahead.
All right, so I'm trying to get, what did the prosecution have to prove, right? Either a dangerous weapon per se. Okay, so how did you prove that?
So if you look at the statute, I put my glasses on, and the jury instruction, when it talked about the dangerous weapon per se, dirks, daggers, stilettos, etc., or any other dangerous weapon. And if you look at the case law that's in the brief, the any other dangerous weapon, what they talk about is the dangerous stabbing knife. If I can have just 1 second, Your Honor. Dangerous stabbing weapon is any other object that is carried as a weapon for bodily assault or defense that is likely to cause serious physical injury or death when used as a stabbing weapon. So that was what they proved, was that the knife, the butterfly knife that was, when opened, approximately 9 inches long, they were able to prove that it was the other dangerous stabbing device.
But he didn't use it to stab anyone.
It's not required under the statute. If under the 2 ways to prove it, one of them is the per se and one is the or in a manner used as. So this one was charged under the per se portion of the statute. That if it was dangerous per se, they don't have to prove that he carried it with the intent to use it as a weapon.
What's the definition of dangerous per se?
That if it was carried as a weapon and that is likely to do so. And that's the fact that Mr. Shaft conceded during his testimony, I believe, that it was a dangerous stabbing weapon.
But there are cases that say that what the police and even what the defendant thinks are not dispositive of this issue, correct?
Correct. And it is a jury question. I will concede it's a case law establishes that. And I think if you look at the way this was charged, and again, we're here on a sufficiency argument, so we have to look at it in the light most favorable to the verdict, to the prosecution, that he was charged under this statute with 3 separate knives that were in the car. 2 of the 3 knives the jury acquitted on. There was a hunting knife and one other knife. So he was charged
with Army knife,
yep.
Right?
Correct. So the jury looked at it as that this butterfly knife was essentially, I think you can infer from their verdict that it was different than the other knife. That one is what they believe constituted the per se dangerous weapon, where the other two, they just flat out acquitted on.
What evidence did the state produce at the trial that to demonstrate that it was a dangerous weapon?
So they presented both officers' testimony about what they observed with the knife. And then they just presented the knife itself to the jury, so the jury could make that determination for themselves. The actual knife, I believe, was admitted into evidence, as well as the picture of it that I included in my brief with the ruler, the tape measure next to it.
Right.
So I think the testimony of the officers, and then the prosecution didn't present it, but Mr. Schaff testified in his own defense, plus the knife itself. So I think the jury could then make that factual determination.
Is this different than People versus Brown, where what the defendant had in his car was a machete? And the court said the fact that the defendant testified that the machete could be used as a dangerous weapon does not support a conviction under the statute.
I think with the machete, I think the concern here was the smaller size of the knife could be used as dangerous because it was more.
So a machete can be used validly, right, when you're
Correct.
chopping away brush, let's say.
Yes.
What
In the Amazon. In Grosse Pointe. A lot of people, they always see these gardeners out in the Grosse Pointe machete.
So I think with the machete, Your Honor, I think it would be,
it's different if it's, to me, I think of per se as designed for purposes of offense or defense, right?
correct.
For that specific use. Did anybody testify to that, or it seems to me, the difficulty that I'm having with this case is the conclusory nature of two police officers saying it's a dangerous weapon. And without explaining why.
And I think, I think if you look at the knife that the jury looked at, I think the jury could come to that conclusion just based on one, the officer's testimony, but also just the knife. So as to the machete question, I know, and I'm just thinking here, machetes aren't necessarily stabbing. And I'm not a hunter, so I'm not super familiar with them, but this knife was very sharp. I believe it was a double-edged butterfly knife.
Had a little, we saw the picture.
And so I think with a machete, I think it's just not, machetes you can cut with, but I don't know if it's necessarily a stabbing weapon, where I guess I think of machetes where people are chopping things with them as opposed to stabbing things with them. So I think that's how you could
Is it
differentiate
legal
that.
to have a butterfly knife in Michigan?
I don't think it requires a concealed pistol permit, but I don't necessarily think whether or not it's legal to have is necessarily the question. The question is whether it's legal in the car, because it was in his motor vehicle, which is charged under the carrying a concealed weapon statute.
It is somewhat distinguishable from the other knives that were in the vehicle, which had other purposes, including apparently spreading peanut butter. So,
Yes. And I think that, like the hunting knife, for example, that the jury convicted on, I would say that it's probably, and I didn't include the picture of that in there because he wasn't convicted of that count, but I think the hunting knife that they acquitted on was probably more akin to the machete as opposed to this very, very sharp, inconcealable weapon, where I think if somebody pulls a machete out.
he said that he used the butterfly knife to perform tricks.
And I think as a credibility question, I think that was, if you infer from the jury's verdict, that they didn't credit that testimony. And if he said, I used one to make peanut butter sandwiches and one to do tricks, I think the jury, the rational inference from that verdict, that they did not credit that testimony.
Does it make a difference that he didn't disclose the presence of the butterfly knife, but he disclosed the presence of the other two knives?
I think it does, because as I was saying with the machete, with the butterfly knife and it being, you can flick it open with one hand. I think that's what makes it more dangerous, is essentially the element of surprise, where I don't think you're going to surprise anybody with a machete if you pull it out, but the smaller, sharper knives, I think it's a whole lot easier to stab somebody when the definition is other dangerous stabbing weapon with a smaller, more concealable, sharper knife as opposed to a large, I want to say duller, but machete that's probably easier to cut as opposed to stab.
Well, I understand there is some commonality. The butterfly knife is not a switchblade,
Correct.
but it functions like a switchblade because you press it and
It doesn't even, when I actually had to do some looking on this, when I was looking as I was writing the brief, and I believe the officer's testimony was you don't even have to push a button. I think it's more just like a wrist flick, where the switchblade, I think it's kind of a thumb button for this one. Because when I was writing the brief, I was Googling like what actually defines a dirk, a dagger, a stiletto, all of those things in the, yes. I was on Google trying to figure out what the actual definitions of the listed per se dangerous weapons are, as opposed to the other dangerous stabbing instrument. In this knife, and I believe the officer even testified, it's opened with the flick of a wrist. So I think it's more akin to a switchblade.
so there are the named instruments.
Correct.
Then there are other dangerous, which are divided into two categories. The per se, and then whether you have to show the intent.
Correct. So the other dangerous stabbing weapons fall under the per se. If you look at the statute in the jury instruction and the way this was charged, if it's the other per se dangerous, you don't have to prove the intent. It's if it's not per se dangerous, you have to prove the intent. And I will concede the way this was charged and the way this was instructed to the jury, it was only charged under the per se portion of the statute, not the having to show intent portion of the statute.
No,
Please.
please.
No.
Did the jury instruction have to do with whether it was a per se dangerous weapon? I thought it had to do with whether it was, the other dangerous weapon, whether it was intended for use as a weapon for bodily assault.
When I look at the jury instruction that I have cited in the brief,
0.4.
page 194 and 726, which is page 4 of my brief, the second paragraph of that block quote, the jury was instructed, you must decide from all the facts and circumstances whether the evidence shows that the knives in question here were a dangerous stabbing weapon, which is the per se language. So that was the theory that this was charged under. But I don't think they.
I'm looking at that in context in 11.4, and it's the way an object is carried determines whether or not it's a dangerous weapon. If an object is carried for use as a stabbing weapon and is likely to cause serious physical injury or death when used as that.
Is that paragraph 2 of 11.4? So some objects such as guns or bombs are dangerous. Other objects are designed for peaceful purposes, but may be used as a dangerous weapon. And then.
This all revolves around the way an object is carried, not whether it's per se though.
But I think the way that
this seems to go on the, like if there are two ways, it's either dangerous per se or it's carried as with that intent, which I don't think.
I agree, but because the way this was charged was it was dangerous per se. So the prosecution didn't go on the theory of this was charged as it was intended to be used as a dangerous weapon. The prosecution went under the theory of it was dangerous per se as the other dangerous stabbing device. But I don't think when I reread this, the briefing in the trial transcripts, they did not pursue the two ways to get to this theory for knives. It's either dangerous per se or.
Yeah, but this jury instruction seems to go about whether it's intended to be carried as a dangerous weapon. I mean, it says the way the object is carried determines whether or not it's a dangerous weapon. That's not per se. That's the other avenue. That's why I think it's a little confused because most of the evidence there's nothing that there's no evidence that he intended to carry it as a dangerous weapon here.
And the prosecution didn't pursue it that way. So I think that's why they didn't present evidence. They were going under the per se theory.
Right. I don't think that's the jury. Okay.
That was when I read this, like, there's when you're dealing with knives or stabbing instruments, there's two ways, and the prosecution only presented evidence as to the first way. I would concede that they did not present evidence of intent. And I would argue that it's because they were under the other theory.
I'm sorry for interrupting.
No, that's, you did not interrupt. I think that's the issue that we're all struggling with. You know, we hope things can be clarified in construction. And I get it. They use guns and bombs. That's not a knife.
Correct.
So, you know, the question is, for example, like a martial arts star, that it's an instrument that's designed for offense or defense. That is a per se dangerous weapon. And that's what I'm struggling with here. What's the evidence that this butterfly knife was designed for purposes of offense or defense? And I get that the officers provided this conclusory testimony and that the defendant opined himself that it could be used in that manner, but not that it was that. And so like the machete, then does that mean that testimony is insufficient? You
And
see where you see.
I see the argument
now see
completely.
the struggle.
Yes, no, I completely understand where this case turns. And I think it's just a matter of, and I guess in closing, I would
The
say,
standard of review.
The
and
standard of review is
sufficiency of the
sufficiency.
evidence is that you view
Yes.
the evidence in the light most favorable to the prosecution, and you make all inferences in
the
favor
verdict.
of the verdict that they came to.
correct.
Is it your position that in a case such as this, where the prosecution charges the weapon is dangerous per se, that it's similar to a strict liability issue, and that all that the state has to do in order to prove in order to present sufficient evidence rather, is to show a picture of the instrument and say, look at this, it's a deadly instrument?
I think it's not just the picture. There was the testimony of the two officers, the testimony of Shaft, as well as the instrument itself was presented. So, because for example, under the other subsection of the statute where it's having the concealed handguns in cars, that all you have to prove is that it was a gun and in a car. There, you don't have to prove. If someone's charged with CCW, then the elements are essentially you have a handgun in a car
And
without
it's
a concealed criminal,
right?
without a concealed pistol license. And so I think when you're under the Dirk Stilettos, daggers, or other dangerous stabbing instrument, I think it goes into that. You don't have to show what the intent was. If somebody has a gun in a car without a pistol license, you don't have to show what their intent to do with that gun. The fact that they had the gun in the car is the charge.
It does say guns, was it guns or bombs?
Right,
Yes.
guns or bombs.
Yeah.
So, I mean,
Yeah.
it doesn't say and butterfly knives.
Right, from the Philippines.
Yeah, I mean, you know, it would have been helpful probably to have some background about what, I don't know, what is this legitimately used for? You know, do people do tricks? Do people actually do tricks with, I mean, I think one would not be wise to.
I don't think it would be
do
wise to do a
tricks
trick with a
knife, with
9-inch
sharp knife. Yes.
knife. I would agree. And I think that was part of the jury's calculus when he gave his reasoning for why he had this gun. Maybe making a peanut butter sandwich with a machete, they could see maybe, but, or with
Well, it
the
had-
camping
the
knife.
other knife did have peanut butter on the
Yes.
end of it. I mean,
So, and I think again, they had the benefit of Mr. Schaff's own words, his testimony, and they could look at it and, I mean, I would assume a juror would ask themselves, having this knife, would I do tricks with this knife? And I think there was legitimate factual basis for them to discredit that reasoning, that testimony.
No more questions.
No more questions?
Thank you,
All right,
judges.
thank you very much.
Thank you.
thank you.
The matter has now been submitted. We will now call item number 3, docket number 372571, Jaffarian Bishop v. Banks. If I pronounced that correctly.
Excuse me. Good morning, Your Honor. Skeet Bank appearing on behalf of the plaintiff appellee, Nadine Jofarian Bishop, I believe is the pronunciation on this. Lot less interesting case than the last one. The appellant.
They're all interesting this month, I think. I think
Well, except for-
we've discussed almost all of them.
Except for this one. The appellant, the city
But
of
we
Detroit.
watched the video, so.
But the appellant, city of Detroit, not endorsed for oral argument. The co-defendant is also an appellee since this is a liability issue. But yeah, this is straightforward factual dispute regarding liability. I mean, our client was a passenger on the bus. She was driving either vehicle. She didn't see the accident. So we're relying on the testimony of both the bus driver and the truck driver, and there's conflict there. The bus driver says he was just rolling down the street, got turned right in front of. Truck driver says, well, no, he was he was ignorant.
And so I just went.
I just went, exactly. Now, I think this is a question of fact, jury, and I think that what the judge said is, well, there's a question of fact as to whether or not this turn signal was on. So I'm letting this all go to the jury. And I think that was an appropriate resolution here. Testimony conflicted, jury's got to hash it out. So unless there are any questions, I will rest and allow co-appellee to give argument.
What evidence do you have that the driver was grossly negligent?
The evidence is just that he kept his turn signal on for, if you view the evidence in a light most favorable to the plaintiff, for 5 to 10 minutes since he last would have used it. That's really the only evidence. Now I'll acknowledge that the evidence of gross negligence is thin here. But I think what the judge said is, well, we have to resolve this issue regarding the turn signal. So I'm just going to let it all go to the jury.
Thank you.
Morning, Your Honors. May it please the court. My name is Olivia Palia. I'm appearing on behalf of appellees Christopher Banks and Revive Transport. I think Brother Counsel pretty much hit it. This is a quintessential case where there's a question of fact and the trial court got it right. So I'm going to rest on my brief with that unless you guys have any questions, to be honest.
Oh,
Yeah.
Same question.
yeah, same question, I guess. What evidence is there that the driver's grossly negligent here? The turn signal, that's it, right?
Turn signal, I think you have to remember this is to be viewed under a totality of circumstances, again, in the light most favorable to the plaintiff. And I think given the conflicting testimony between the two drivers, turn signal issue, I don't think the video evidence was properly before this court or the trial court, but even if you consider it, it doesn't show the actual sequence of events immediately before or during the accident.
Doesn't show the accident.
Mhm. Yeah.
So what you're saying is everybody my age and above is grossly negligent because we all drive with our turn signals on for long periods of time.
I'm not saying that, but Elon Musk might tell you that so you buy an AI car one day. So I just think when you look at the totality of circumstances, though, it's at least a question of fact on both issues.
Thank you very much.
Thank you very much.
I have one remark. And it happens every case call, it seems to me. Somebody that is arguing refers to the panel as you guys.
Apologize, Your Honor. It's a Michigan thing.
Yeah, and I know my kids tell me all the time, that's how we talk, Mom. But
I have a son and a daughter, and I say it to both of them, and my daughter corrects me as well. I need to listen to her, obviously.
but I appreciate just bringing it,
Yeah.
just
Yeah.
putting it out there.
Yes.
So-
Between you and her, I will now remember. Thank you.
Thank you very much.
Thank you.
The matter has now been submitted. We will now call item number 4, dockets number 369-519, 370-605, 373-564, and 374-353, Bauer v. Weidelick. And please correct me if I'm pronouncing that incorrectly. Weidelick.
Just give me a moment since I have 3 cases in a row. Good morning, Your Honors. May it please the court, Trish Haas appearing on behalf of the appellant Timothy Wadelick. I would request that the court allow me 5 minutes for rebuttal. So obviously, these are 4 consolidated appeals, although the reality is that all of the main issues in this appeal are related to some fundamental issues in family law with regard to the difference between routine decisions and the difference between important decisions that affect legal custody. Unfortunately, the trial court erred as a whole in mixing up the 2 concepts. And because of that, that resulted in a finding of criminal contempt against my client.
I think it was civil contempt because it's ordering a payment to the other party, not to the government. So even though they mistakenly called it criminal contempt, it was civil contempt. And I also think that you need to file an application for civil contempt. We had a case about a month ago. It's not a final order.
Well, I respect what you're saying, Judge Ackerman, but since the trial court specifically made a finding of criminal contempt.
We have case law saying it doesn't matter what the trial court describes it as if they're incorrect in calling it criminal contempt when it's civil contempt. No, we had a published case on this about a month ago discussing that. Alpena County v. Tadajewski. I actually wrote it. Sorry.
Wow.
It's very, very much top of mind. So I guess like some panels may treat a claim of appeals, and that's where we don't have jurisdiction as an application and grant it, especially in a case where it's final, non-final, because you could file an application after it's dismissed. But I believe based on that case law, we don't have jurisdiction over a claim of appeal from a non-final civil contempt order.
Well, I do believe that this court does have the authority to treat it as an application and still rule on the issue nonetheless. In light of the fact that you stated that this ruling was just issued a month ago, I mean, obviously I was unaware of that fact. So it would significantly prejudice my client for this court to not hear the arguments nonetheless, especially when the trial court clearly erred by identifying it as criminal contempt. I mean, I understand what you're saying, that there's a new case that clearly I have not read. I'm not going to state otherwise, but it would be an injustice to my client for this court to not hear it at this matter, because my briefs were submitted long before.
But it's always an injustice not to hear a case. That's insufficient. That's an insufficient reason to vest this court with jurisdiction.
Well, respectfully, under the circumstance of this case, and because my client believed it was criminal contempt, I believed it was criminal contempt. I think the
Kind of
court
negates some of the arguments that it was civil contempt with a due process challenge, right?
I'm sorry, can you repeat that?
I think one of the challenges is that it's due process concern with criminal contempt.
Yes.
Notice, but would that apply still if it's civil contempt?
No, obviously there's different notice requirements. I'm aware of that. But okay, well, what I'd like to state though is regardless,
Yeah, we have a case law directly on point saying it is irrelevant whether the trial court labels the contempt as civil or criminal. We've done that many times. So
okay,
to clarify that point.
okay, well, let me move on then. So even if you do not hear the contempt, obviously my client does have an appeal of right as to the attorney fee resulting from the contempt finding.
I would think we wouldn't. Yeah, so the attorney fee is part of compensatory civil contempt, and under Maroon, we don't have it's not non-final, so.
Well, according to the court rules though, and in a post-judgment.
It's not a post-judgment award of attorney fees at cost, though. It's part of a contempt. The contempt order has damages, and one component of that would be an attorney fee. So it's not an attorney fee as such. It's not a separate post-judgment award of fees or costs. So that I don't blame you for not knowing this case was not published. There's no fault to yourself, but I think we had a case directly on point with this about a month ago. Like same exact situation with whether it's a
Judge Ackerman, you are just beating me up this morning.
I'm so sorry. I'm so sorry. I don't blame you. I don't blame you.
At least I could say it with a smile, and at least all of you are smiling as well.
I mean, to your point,
could treat it as
an application and,
Yes.
and we'll all move on with our lives.
Yes. Okay. So with regard, let's talk about the core issue here. And there really isn't a lot of published case law that makes a distinction between what constitutes an important decision, which rises to the level of affecting legal custody, versus what constitutes a routine decision, which such rights are vested in a parent when they have their parenting time. I believe that the trial court in this matter has made a significant mistake in determining that many of that the purported transgressions of my client rose to the level of a violation of legal custody. First and foremost, I mean, yes, there's no dispute my client did not have legal custody, but he had equal parenting time. And under MCL 722.27A11, a parent is granted the right to make all routine decisions during his or her parenting time. And again, by contrast, a legal custody question involves a matter that will significantly affect the well-being of a child. My client was found in contempt of court because of the fact that he administered an at-home blood test that was purchased in March of 2020 during COVID. It was a simple finger prick. There was no evidence in the trial court that the simple finger prick test in any way significantly affected the well-being of this child. And most certainly it should have been considered a routine decision, just like administering first aid supplies, cough medicines are considered routine matters under the Michigan Child Support Formula. Likewise, when interpreting the Child Custody Act, it should be read in pari materia with the child support formula, Michigan Child Support Formula. And there's no indication that an at-home finger prick blood test would in any way implicate mother's sole legal custody rights. So to the extent that the court found that was a violation of legal custody, that was an abuse of discretion and a clear legal error on a major issue. Now, when I'm going back to the contempt, even though you're indicating that it was civil contempt and based upon your reading of the opinion of the judge and your recent case, the reality is that when you asked about due process concerns, I still believe there is a due process concern because my client he believed he was on notice for criminal contempt. Because of that, he subpoenaed the 17-year-old child to testify. Everything else would have been hearsay. So there was no way that my client could have defended himself without the ability to call his child as a witness. He was 17 years old. And I understand that that's frowned upon, but when you're defending against contempt, and especially at the time what my client believed to be criminal contempt, it was an abuse of discretion for the trial court to not allow my client's child to testify under subpoena.
What testimony would the child have given that the court wasn't already aware of?
Well, I guess there was a question of fact, first and foremost, because mother considered it a blood test and father said it was a simple finger prick test. So in that regard, the child could have explained exactly what happened and he could have clarified that it was not a blood test, but rather a simple finger prick test. Likewise, there was issues with regard to whether the child was missing school excessively, and the mother questioned whether or not the child was in fact sick. The child could have explained that he was in fact sick and that it wasn't a matter of him trying to get out of school or trying to take advantage of father or anything along those lines. So that is the testimony I believe the child could have provided, which would. Okay.
The court didn't make it solely based on missing up the school, although it did alter the parenting.
Yes.
Given that this child was in danger of failing grade due to the excessive absences.
Well, and that's a problem. I mean, obviously mother had a duty to communicate that to father and she did not. Once father was notified of the fact that it was an issue, it no longer became an issue. The child has since.
Didn't think that missing 17 days of school was a big deal.
If they were excused absences, no, the child was sick. He didn't believe it was a big deal because the child was in fact sick.
Was it wrong for the trial court to take notice of the fact that the child only seemed to be sick when it was with your client and not when it was with its mother?
I don't think the trial court erred in that regard, no. Wow. And Judge Letica, I mean, you authored LSE versus GALS, or you didn't author, you're a participant in that case, wherein you held that, attorney fees can't be awarded in a criminal case of contempt. So, but again,
I believe I was the dissent.
you were the dissent? Oh my
Yes.
goodness. Ooh, boy, did I mess that up. I'm on a roll this morning.
It's okay. They didn't take it up.
Okay.
Surprisingly, she didn't want to appeal a case against her stalker. So
Okay.
the legislature will address it.
Maybe. So going back to the issue of routine versus a significant impact on the child implicating legal custody. In this matter, there was nothing that implicated legal custody, nothing that infringed upon mother's rights in that regard. And in that regard, for the court to then make a ruling that essentially eviscerated father's rights to make any routine decisions in this matter was an abuse of discretion. Clearly, we cannot have the micromanaging to this level where a father would have to take children to mother's house so she could decide whether or not they are sick. It's simply untenable. And it's micromanaging parenting, which a parent is allowed to make routine decisions during their parenting time. And deciding whether a child is sick before going to school is simply a routine matter.
Her mother's a nurse, right?
Mother is a nurse, yes.
And this didn't happen in a vacuum, right? Your client lost custody because he was constantly taking this child to the doctor. Correct?
Yes.
So whether we call it a blood test or a pinprick, where then you test the blood, which is why you prick the skin, be that as it may, seems to me that he's falling along those same patterns, right? That the excessive absenteeism, look at any kid. I think you can take judicial notice. If I had a parent who I just went, oh, my stomach, oh, you got to stay. Oh man, I would have had a lot of stomach aches as a little guy. I can tell you that. Even though I went to school, it didn't do me much good, obviously. But be that as it may, I think that's where your client kind of gets himself into trouble. He seems to be, whether you want to call it Munchausen by proxy or whatnot, which nobody is. But this seems to be the issue, right? That he's over, sort of really turning this little fella into a hypochondriac.
Well, the judge did order that the child be seen by a GI doctor. So clearly the court was aware that there was some legitimacy to what my client was indicating was wrong with the child. And mother, on the other hand, was not willing to take him to the doctor. So,
well, that's not true, because my memory of the record in this case indicates that mother did in fact go to the pediatrician after father told her about the gastro guy. And long story short, didn't she make an appointment for a gastroenterologist for this child?
she did only after the court ordered her to do so. That was in the order that was appealed.
It that way, but I'll take your word for it. Okay.
Yes. I could look up the order, but
No, that's fine.
yeah, I'm pretty confident the last line of the order indicates that mother must take the child to a GA doctor. So there was some legitimacy. And to the extent that his past pattern, you would consider that relevant, I'd like to point out that was from 2018. These parents were co-parenting effectively for 5 or 6 years before this motion was brought. So obviously there had not been a pattern of behavior, and mother had acquiesced to father making the decisions about the schooling. Mother, and here's the thing.
What do you mean there wasn't a pattern of behavior? That's why your client lost custody. There was a pattern.
But that pattern had not continued is what my point is, Judge Borello.
No, what I'm suggesting to you is that indeed it did. And that this is what you're talking about or trying to minimize is in fact evidence that that same pattern continued on. And I know you have an obligation to represent your client, but for goodness sakes, during COVID, what parent would say, hey kids, I got a good idea for fun. Let's do allergy testing.
Well, it was food sensitivity, Judge Borello. And I would consider that a fun science project personally.
You would, huh?
I would.
Pricking a kid's finger. That's a little odd to me. I think it was to the court. I think it would be to most of the people in the audience. So the unfortunate thing for you is you're stuck with your client's behavior and there's nothing you can do about it.
Yes, I understand what you're saying. I mean, I respect what you're saying wholeheartedly, but I still, as a fundamental issue, I don't believe that a finger prick test would amount to a violation of mother's sole legal custody.
I don't think that's all that was here though, right? I mean, we're talking about the absenteeism. We're talking about a whole myriad of other issues that went into this as well.
But the only reason that he was found in contempt is because of the finger prick test. And in order for him to be found in contempt, the court had to decide that there was a violation of a court order. There's no violation of joint custody, or there's no violation of mother's sole legal custody by a simple finger prick test. Likewise, there's no violation of mother's sole legal custody if he was to administer over-the-counter medications or vitamins or put on a Band-Aid. I mean, the line has to be drawn somewhere, and in this case, I believe the distinction was lost, and that is an important legal principle that should be flushed out because
Dad saying, hey, here's something fun. Let's draw some of your blood and let's see if you, and I recalled it being allergies and sensitivities.
That's what I thought, yeah.
But I mean, I don't know that as a parent, I would have, my kids wouldn't have been thrilled by that. And I don't think it ever would have entered my head to do that. So, you know, to the point, I think I don't know that this is quote a routine medical decision. It's not the child reporting a physical ailment and asking for some relief. It was, let's check it out.
well, it was a routine matter is what I'm suggesting. Either it's a routine matter or it's a matter that affects
It's not-
legal custody.
Okay, so to Judge Barillo's point, on these particular facts with this particular history, and I believe this is the third time that this case has been to this court.
Just a second.
Okay.
I thought it was a third too for some.
And for consolidated appeals here, that clearly something is going on. So.
Well, I appreciate everything you've told me. I will thank you for the education, Judge Ackerman. At least I said it with a
I don't
smile.
blame you for not citing a case that didn't exist when you submitted your brief.
This is a first in my career. Thank you. But I would still like to reserve the 5 minutes for rebuttal. Are there any other questions?
No, thank you.
Thank
It was
you.
very well briefed as
You have
always.
it. Yes.
Thank you.
You want to give them a chance to. There you go. Thank you.
Thank you. I'm used to this. This kind of siren is always in front of my house. So that's why I kind of tune it
See,
out.
I live in the flight path.
Oh,
And,
okay.
and I was sending these guys pictures of bald eagles fishing on my creek from my office window yesterday. So
Awesome.
I don't even know that we have police where I live. And if we do, nobody really pays attention to them anymore.
Maybe it's just a really safe place, Your Honor.
It's a bunch of farmers. So, I mean, if you want to steal soybeans, go for it.
That is valuable now, Your Honor. Good morning, Judge Latika. Good morning, Judge Barillo, and good morning, Judge Ackerman. I have been with this mother, Dana Bauer, right from the beginning. I was there in the 2018 when we'd had to file, as she had no choice but to file. And the history of this case, the fact that you spoke about that is so important because that is, and Judge Tomlinson, the circuit court judge, has been on this case also right from the beginning. So the history of the case really, really is important. The facts of how my client was awarded legal custody is really important. It was as a result of very, very aggressive medical interventions by the father, doing his parenting time without the knowledge of Miss Bauer. And it was shocking to her that it started back again. And it was the reason I believe Judge Thompson found that Ms. Bauer's legal custody was violated, sole legal custody was violated on the medical, it's not a prick. It was actually a little blood test that you get from the drugstore. And he did a blood test and he sampled it and he,
For fun.
well,
That's what he said.
the thing is, he admits it on the record that he did it.
Does admit that he did it.
Then he says he said it was to test for food allergies and food dietary sensitivities, dairy sensitivities. And then he backtracks and he says it was a science project during COVID. When you know that even to do a COVID test, he had asked permission from my client for the kids. So when you can ask permission to do a COVID test, you know that the mother has the authority to make those decisions. You understand that. So this was willful. He was doing this because he gets in his mind that these kids have all these diseases that don't exist for these kids. And the children spend half the time with the mother. So the mother gets to see the children quite frequently. And she's also a medical profession. And I will tell you, in my family, I have a lot of medical professionals. Nobody has ever
So
tried
you're
to do a
the
blood
black
test.
sheep, huh?
Yeah. Nobody's ever suggested that we do a little prick of a blood test in the house. First of all, you can get an infection. Second of all, you don't know how your kid's going to bleed. You don't know what you're doing. You don't know if
Well,
you're hitting a nerve.
listen, we don't need to go to the nth degree with this. I mean, we understand what happened here. We understand the nature of it. And we understand why the judge did what he did. When my assumption here is that you have no problems whatsoever with what the judge did. Is that correct?
That is correct, Your Honor, because I think the judge was very cautious in his determination. We had an evidentiary hearing that went for 2 or 3 days, I believe. And they were long and we had a lot of testimony. So I think that the judge took his time in making a ruling, and he ruled on what was really important, because it was that it's the father's ideas about medical treatment for the children that triggered all of those missed schools. 19 days of missed schools, 2 of those days was with mother, 17 was with father. And the father knew the child was missing school. He knows the rules about the school. He knew it because he was keeping the child home. He never even called mom in the mornings and say, hey, listen, HW is not going to be going to school today because he's sick or he's this. Mom finds out always at the end of the day when she gets a phone call from the school.
He did let it go on for quite a while until she got the letter, which
because this is and I think there was testimony on the record about how mom knows that when she presses Mr. Wadelick's button, he just escalates. And she didn't want that to escalate for her children. She's dealt with this man for a very long time. So I do think the judge.
HW is now 18. So
I was going to just say that, Your Honor. I was just going to say the fact of the matter is, what relief are we really looking for here? HW is 18 years old. And the changes that the judge made and the decisions he made allowed HW to graduate and move on with his life and get away from this, I don't know, Munchausen, whatever syndrome this father has. And that's really in the best interest of the children, what the judge did, Your Honor.
So
Thank you.
as to our prior discussion with sister counsel about the contempt proceedings, I take it you don't have any qualms either with the fact that we are not convinced that we have jurisdiction over the matter at this juncture.
Yes, given that case that Judge Ackerman just stated to us, I do believe that you do not have jurisdiction on that matter.
Let me ask this question, and I'll ask it a sister counsel too when she gets up so she can be prepared. It's one, in this case, it seems to, or not seems, in this case, it's clear that the father filed within the time frame. There is a court rule that allows us to treat such actions as if by leave granted, correct? I think it's MCR 7.2054 B, if I'm not mistaken. So would it be beneficial for your client and for us to take that route and to actually decide the matter? Is that something that you would request of this court? Or would it be sufficient for your client to simply say, this court doesn't have jurisdiction, and if counsel wants to file delayed application, that's what the court rule allows her to do?
So, Your Honor, this has been really financially trying on my client. It is not easy to constantly be in court. She's just a nurse. Mr. Wadelick's financial abilities are much stronger than my client's. For her to keep coming back to the Court of Appeals to do this is really hard. So I would prefer the first option. Go ahead and look at it and make a ruling on that matter. I think we answered the question on contempt very clearly. We think the process was followed, regardless of if the court looks at it as civil or criminal. In fact, the judge mentioned criminal, so there was notice of criminal. They talk about not having notice. They had notice. His lawyer mentioned it multiple times. If the court wants to look at it as criminal.
It's in the order.
It's in the order, Your Honor.
Right.
Number two, having adequate time for defense. The motion was filed in May. It was heard in June. The court didn't have an evidentiary hearing starting till August. It continued till September. There was a ruling in January. There was plenty of time for this defendant to prepare a defense. And I think the other matter was with regards to the ability to process, I believe. Opportunity to prepare a defense and assistance of counsel. He had an attorney all the way through.
What about calling the child?
Calling child. The judge made a ruling. And because of the nature of this custody case over the years, I think Judge Thompson was absolutely right. It would have been really difficult for HW to get on the stand with mom and dad right there and talk for information that everybody knew had happened anyway. What new information was HW going to tell the court? That he had missed 19 days of school, that he had a little blood test done by his father, who's not a doctor or any medical profession. Like, what information would he have given the court that the court didn't already know? So I think that that ruling was correct. Your Honors, and finally, the standard of review, as the court knows, is significantly high for the Court of Appeals to overturn anything with regards to a custody matter. It really does have to be abuse of discretion, clear legal error, and it's the great weight of the evidence, Your Honor. I don't think they've met that burden. Thank you very much.
Thank
Thank
you,
you.
counsel. Well briefed. Thank you very much.
So just
Hang
briefly,
on a second, counsel. Sorry to interrupt you, but before you begin, I mean, this is kind of the issue that's been hovering in my head too, that sister counsel raises. Setting aside just for a second, the issue of the contempt, what other relief could we possibly give your client in this case?
well,
Because the kid's aged out.
with regard to HW, I would concede that he's no longer, that issue's moot. There's no question. But as it relates to AW, who is still under the
Right.
age of 18, his motion to modify legal custody, certainly as briefed, and I didn't want to go into this as much because I thought the other issues that I've been knocked
Sure.
down on were more important. But clearly there was a change in circumstance or proper cause because there was decisions being made by mother that significantly affected HW, which likewise affected AW. Mother was not properly monitoring AW's social media account. So father had legitimate concerns. There should have been at least an evidentiary hearing on the issue of whether he established proper cause or change in circumstance with regard to AW as well. And that's consistent with MCR 3.210 C8C, I believe, going from memory. So
Thank you.
that's one other thing. Now, I just have to, obviously I was blindsided by this morning, but with regard to, here's the thing I'm thinking about. Obviously, my client is a successful businessman. He was very It hurts his reputation to be found in criminal contempt of court, which
He wasn't found in criminal contempt. It's civil.
even though
Keep saying that it doesn't matter what they describe it as. A criminal contempt. He would have to be paying the court. He paid, his ex-wife. That's civil contempt.
Pay a fine, go to be jailed or be put on probation.
well, I appreciate that and I understand what you're saying, but the order nonetheless indicates it was criminal
Oh,
contempt.
There's no doubt about that.
So that's the problem, is it has implications to my client. So to the extent you're not going to address the issue, it's not fair to my client because he didn't have the opportunity to present an argument as to why he was not held in criminal contempt.
You're asking us to decide, to exercise our jurisdiction or, our authority to treat
Discretion.
it, our discretion to treat it as a application. and
I
grant it.
sure am.
Okay.
And it's for that reason, because I understand what you're saying, but with regard to the impact upon my client, an order that indicates he's in criminal contempt, a person searching his records isn't going to know
Would
that.
an order saying that there's no jurisdiction because it wasn't criminal contempt clear some of those concerns, though? It was.
Well, obviously it would.
He was only
Obviously
held-
it would,
He was held in
yes.
contempt, but it was only civil contempt.
To that degree, yes. I mean, it certainly would clarify that. I mean, I appreciate that. That's my point, is we can't just say we're
I
not
mean,
hearing it.
either way, I think we have to address whether, as a preliminary matter for our jurisdiction, whether the fact that it was civil contempt, I think, is necessary. So I think at minimum, we'd have to clarify that it wasn't criminal contempt.
And I would agree with that. Like I said, at least my client then is getting some of the relief he sought because, having a
There's-
finding
there's-
of criminal contempt.
That gets rid of the due process argument about it to begin with, right? So.
Well, it does. And like I said, the reason he brought the appeal, most importantly, was there was a finding of criminal contempt in an order, which he was aggrieved by.
Dismissing wouldn't find, because it wasn't criminal contempt. Okay.
Yes. Do you understand what I'm saying? I mean,
do.
at least that would give him some relief. So I was hoping
Yeah.
at least if you're going to address it that way, rather than just saying there's no jurisdiction, you understand what I'm saying?
And I think we're running out of time. If you
Okay.
have any final points?
Okay.
Do you have any
Just the final point is, I did check the order. It did order that mother was to take the child to the gastroenterologist. So there was an issue with that. And the only problem with why the court should consider it as leave granted is because the time for my client to file an application for leave to appeal has now passed. He would have no remedy to
I
actually.
think if you dismiss for lack of jurisdiction, you'd have a renewed period to file an application.
you're
That's what we were.
Under our court rules.
Under our court
Okay, well
rules.
then, to that
The
degree,
Supreme Court.
I would just agree with sister counsel then that it would be much better if this court resolved this issue rather than having the parties be involved in future litigation. Thank you.
That would be great for us too.
Yes.
Thank you.
All right, we will now call item number 5, dockets number 372150 and 374999. Radha V. Mohammed.
Hello again, Trish Haas appearing on behalf of the appellant Ahmed Mohammed. I would like to reserve 5 minutes for rebuttal. And by the way, I have full.
Can you hear us?
Yes, I can hear you. I can sometimes not hear Judge Letica, but I can hear the rest of the panel.
That's what her husband says. I know this for a fact.
I can tell you that I've figured out that I can hear Judge Letica when the camera is focused directly on Judge Letica. It's when it's focused on the courtroom as a whole or any of the rest of you that I can't hear her.
All right, then I'll speak up when I have a question.
So I will tell your honors that the case schedule this morning gives me newfound appreciation for the difficulty this court must have in keeping everything straight. So I fully wholeheartedly appreciate the difficult jobs you have. I just wanted to start with that. But what the issue before this court mainly involves, it's a change of custody and change of domicile matter and an issue regarding attorney fees. So first and foremost, it is our position that the trial court did abuse its discretion when it granted mother's change domicile motion. The reason, and there are several reasons for that. First of all, many of the trial court's findings are against the great weight of the evidence. and I will go specifically, and I know I don't want to reiterate everything in my brief, but I think first and foremost, it was clear that the trial court in its deliberations was not focusing on the children, but rather was focusing on mother and her needs. With regard to factor A, the court found that mother met her burden by preponderance of evidence because she would be a happier mother in Canada. Well, that seems very
Right
speculative.
now, we probably all would be.
Except with regard to medical care, perhaps.
A little cheaper over there.
Yep. But I like your humor. Thank you. I needed that this morning. So the issue, finding that mother is happier is not a reason to grant a change of domicile. The mother had the burden of showing that by preponderance of the evidence that it would improve the children's quality of life. And
Well, the judge says her family's there. Is that correct? Isn't that correct? She has family.
some of her
there.
family's there.
He did actually speak directly to healthcare and
Healthcare.
the fact that it was covered, that all of the children's healthcare would be covered in Canada. He did speak to the fact that the school system that the children were going into seemed to be a better school system than the one that they would go to. I can't remember if this was Dearborn or Detroit, so.
It was Dearborn. Your
Was
Honor.
it Dear? Thank you. So my point just being, there were other factors
Well, and
that were considered, or they're not.
there were other factors, but there really wasn't evidence. Mother didn't even provide the court with testimony about what the names of the schools would be. She also couldn't provide the court with the names of the doctors. She referred to the hospital that the children would be going to in Canada as the Six Kids Hospital. I mean, that wasn't actual evidence that there would be improvement in the children's life. I mean, usually when you have a change of domicile, you compare the children's schools. Mother didn't do that. It was just her opinion that it would be better. But meanwhile, it was disrupting the children because they already had an established pattern here in Dearborn. So to the extent, and I understand what you're saying, but
And
there's-
there was also an issue, if I'm not mistaken, about interference with from your client's family, degrading mother in this case.
well, those were mother's allegations. But obviously there was conflicting testimony on that. And regardless,
Which the court resolved, I think.
Didn't believe your client, believed the mother here, right?
the court, you mean?
Yes.
Yes. I mean, obviously,
So why should we not accept that finding?
well, obviously this court defers to the trial court with regard to issues of credibility. I can't deny that. However, if you look at the evidence as a whole, remember I discussed this confirmation bias with you last time. Mother made outrageous allegations at the beginning of this case, but when you actually look at the testimony that was adduced at trial, many of mother's allegations were not substantiated. And in fact, she was the one who was found to engage in domestic violence. She admitted that she bit father's hand in the car. It just seems to me that the trial court was was searching for confirmation of its first impressions of this case, that it precluded the court from having the ability to judge this case in a fair manner. Because there was plenty of evidence that's contrary to what the trial court found. I mean, to the extent that mother even admitted that she was moving in part because she wanted to limit father's parenting time. Well, that's a consideration under the change of domicile factors, whether or not the move was intended to defeat father's involvement with the child. And to the extent that mother admitted that, I mean, the trial court should have weighed that. I don't know why the trial court would have not considered that in its rulings. Clearly, the children need both parents regardless. And if you have a mother who's willingly admitting that she's trying to diminish the time between father and child, then that's problematic. So that's one reason, Judge Borello. Also,
So confirmation bias.
Yes.
Right? And insufficient evidence, correct?
yes.
I just want to make sure I'm distilling, if you will, these arguments correctly. Thank you.
Distillation is excellent. The other issue is that, father explained that, it wasn't, obviously this was a very volatile relationship, as we see all the time in divorce cases, nothing new. But to the extent that the trial court faulted father alone, when the evidence was admitted that they both engaged in arguments. They both engaged in name calling. This wasn't just one-sided. And I mean, also the other problem that I have with the trial court is that it inferred that mother was emotionally abused. There was no expert testimony that stated that mother was emotionally abused. There was no record evidence of that. That was just his conclusion. And to say that mother is emotionally abused when she had access to $130,000 in the bank and access to 8 credit cards, that's not something that we would normally, on its face, doesn't look like emotional abuse. I mean, certainly we have cases in which parents are controlled financially, but and the court was inferring that from its decision, but the evidence didn't support that finding. There was no emotional abuse here.
Emotional abuse that doesn't have to be financial related.
Well, but that was what the court relied upon. It said that, father was, treating the mother like a child, that he wouldn't let her spend money. Those findings really aren't supported by the record. That's my point. And again, there was no expert testimony that was emotional abuse. So I don't know how the court could have reached that conclusion. And also the other things about the emotional abuse, the court made note of the fact that parties kept their keys in a metal box. And it was unequivocally established that that wasn't an attempt by father to control mother, but rather to prevent their key fob from being copied. That's why it was placed in a metal box. But for some reason, the trial court inferred that that action meant that father was trying to control mother, and there just simply wasn't any evidence of that. The other important thing, Judge Grello, is that when you're looking at a change of domicile action, the children always have to be the primary focus. And here, the trial court's order was not fair to these children. It forces these children to be in the car a minimum of 8 hours every other weekend. The trial court didn't take into account that in recent years, we've had border closings where there is no ability, or weather-related issues. It's a minimum of 8 hours. It's not fair to these children to be placed in the car 8 hours simply so mother can move to Canada to be a happier mother. So with regard to the actual custody decision, the court found that mother had a sole established custodial environment with the children. But I think this is where the trial court erred most egregiously, because under Sabatine v. Sabatine, the Michigan Supreme Court case, when evaluating an ECE, the issues that control are what has happened during the separation period. The trial court in this case was focused simply on the roles of the parties before the divorce. But obviously their separation period was over a year. Father was involved in taking the children to school. Father participated in dental appointments. He participated in medical appointments. He took the children to counseling. And it seems like the trial court just simply didn't take those matters into consideration and instead focused on the pre-separation period. So it was an error for the court to find that it was just mother had a sole environment. It's not consistent with Sabatine. The other issue is also that the trial court's findings with regard to factor A and B are really at odds with, I don't know how to say it. It's Bofisil. I'm not sure how to say it, but under Bofisil, the court in a published opinion explained that we can't fault a working parent with regard to its evaluation of factor A and B. Just because a parent works does not preclude a finding that or does not indicate that a parent's love is any less. And the trial court was overly critical of father because he was a working parent, which to me was absolutely against the holding in Bofisil, which said that that it shouldn't be held against a parent when they're working full time, and that it doesn't mean that that parent loves the child or that the ties are any less. So that was definitely an issue that the trial court erred on. Also with factor C, this child had significant dental cavities, was missing, had a tooth pulled, and the trial court really makes no mention of that in its findings. And that was a serious matter. The fact that this child's dental care was neglected is something that the trial court should have looked at. And overall, the fact that the trial court allowed
I was waiting for you to bring this up because
I was
just
waiting for
last
you.
month,
Did you like that, Judge Brill?
yes, you argued the complete opposite. So the kid had a cavity and went a year without getting filled.
But Judge Brillo, you schooled me, so
What's the problem?
But you schooled me, Judge Brillo, and you told me that that was a serious issue.
Child abuse, yes.
So
Anyway,
Yeah, so likewise, in this case, it was
Absolutely.
something that the trial court should have looked at, and it just didn't. And I mean, it was so focused on what mistakes father had made as a parent that it really didn't objectively evaluate the mistakes that mother had made as a parent. But the other issue is, under the Child Custody Act, stability is always favored for children. And the fact that the trial court found that factor D favored mother, or they were found equal, it can't be reconciled with reality. Changing domicile is absolutely going to interrupt this child's stability. The child had a large family here in Michigan. The children were in school. It simply was not, it cannot be reconciled with the Child Custody Act to find that factor D should have favored father because it was keeping the children in the same established custodial environment that they were accustomed to. The only other thing I'd like to say about that is with regard to factor I think the child's preference. Here, before the trial court issued its opinion and order, it did not make any, it did not interview the children. And it's black letter law that any child over the age of 6 must be interviewed in a child custody proceeding. So once father filed a motion for stay, the trial court realized that it made a mistake and said, oh, I'm going to fix it. I'm going to interview the child. Well, there's 2 problems with that. First and foremost, the trial court had already made its decision before it scheduled the interview. And second, the trial court scheduled the interview over Zoom, which is not appropriate. Father requested an in-person interview of the child because he was concerned about the outside influences, and the trial court denied that request. So there's 2 errors. The trial court did say that, correct. But, I mean, there's a preference.
Bringing children to court in my past life was not my favorite thing to do.
I understand.
Yeah.
But
Not
just like
young children, it's not super friendly.
I understand, but just like evidentiary hearings are not proper for Zoom, and the court rules kind of indicate that. This is just an extension of the evidentiary hearing, and and especially when the trial court said a preference couldn't be formed, that's a determination that would have been much better made in person as opposed to over Zoom. Okay. So let's go then the last issue. Okay. The motion for fees. There was 2 motions for fees that mother had filed. And the trial court made a determination that based upon mother's inability to pay, that father should pay her attorney fees. Well, that was entirely problematic and a clear legal error, because it's black letter law that when you're evaluating a person's ability to pay, it is not just whether or not they have income and whether they have a job, but rather the court should look at whether or not that parent has no money in bank accounts, whether the resources are depleted. And here the trial court's only inquiry was, well, mother is not working, therefore father has to pay her fees. Well, your opinion, Judge.
This is a post-judgment award of fees or costs.
Yes.
But we do jurisdiction this time.
No, I was talking about your, gosh, I have to find the name of the case that I cited you were on the court. Let me look at my notes. I don't know where, Andros. And the issue of judicial estoppel. In the change of domicile hearing, mother proffered that she should be granted the move to Canada because she could find employment. And the trial court relied on that when it made its ruling with regard to change of domicile. So to the extent that mother now came to court after she's in Canada stating, I need him to pay my fees because I'm not working, she should have been judicially stopped from proffering that, because that was not her position in the change domicile. It was an absolute contrary position. The last thing on the issue of attorney fees is, father clearly questioned the reasonableness of the fees. He was very vocal about that through counsel. And despite that, the trial court did not hold an evidentiary hearing about the reasonableness of fees. So since father contested the amount of fees, I think it's black letter law that father should have been entitled to an evidentiary hearing on that issue. So what I'm asking for is that the trial court reverse the trial court's change of domicile and change of custody ruling based upon the more detailed factors enumerated in my brief beyond which I've just stated here today. And that furthermore, that there would be a reversal of the attorney fee issue because mother didn't properly establish an inability to pay. The court didn't consider that she had $150,000 in a bank account. And these are things that the trial court should have considered before it made a determination that mother was unable to pay. Further, mother should have been judicially stopped from relying upon the fact that she was unemployed when the trial court previously relied on that when determining, when granting the change of domicile. Any questions?
No questions. Thank you.
Thank you very much.
Are you ready?
Morning, Your Honors. Lisa Schmidt, appearing on behalf of appellee Rana Rada. Appellant has used a shotgun approach in this appeal, hoping that if he challenged enough parts of the trial court's very thorough and reasoned opinion, he might land on something that this court would reverse so he can continue to escalate the cost of appellee escaping an abusive marriage. Appellant asserts the only rational explanation for the trial court's domicile and custody findings is confirmation bias. I suggest that the judge listened to 6 days of testimony and weighed the credibility of the evidence and found mother credible and father not. Father further asks that the court reverse the trial court's, again, very clear findings regarding the need for attorney fees because she wasn't working. The problem is that her position throughout the entire case had been consistent, that she was going to school and she could not both go to school and work full-time, and that it was not until her schooling was done that she would obtain a job. That was what the trial court relied on in its decision, and that was what the trial court relied on in awarding attorney fees. I'm doing that one first because recency means it's the one that's closest in my memory. So we'll do with attorney fees first, and then we'll go back and talk about custody. The trial court did dismiss mom's first motion because she had not provided the facts required to demonstrate the specific reasonableness of fees. She corrected that error. She provided a bill of particulars. And according to Reed versus Reed, we need either an evidentiary hearing or findings of fact. We have findings of fact. Father contested the basis for attorney fees, not the amounts, not the billings. It was the basis that father was challenging. And so we did not need to dig into beyond that bill of particulars that was provided. Trial court properly made findings based on the bill and properly awarded attorney fees. Let's talk about custody because that's the bigger issue here. First of all, I need to be very clear because sister counsel, I think, got a little bit confused. This is not a change of custody case. This is an initial custody determination in a judgment of divorce. If it weren't for the fact that there was a consent temporary custody order in March of, I believe it was 2023, they wouldn't have even fallen under the change of domicile statute at all. For her to argue that the change of custody situation was not clearly demonstrated is, I don't think it's disingenuous because I don't think she intended to get that mixed up, but it is incorrect. This is an initial custody determination. In her reply brief, sister counsel asks this court to use the Sabatine idea of determining established custodial environment as of the time of trial and apply that to the entire best interest analysis. And that is directly contrary to Vodvarka and other published opinions, which demonstrate that we need to look at the pattern of conduct by both parties throughout the case in awarding that initial custody. Even in a post-judgment case, you can use the pre-order conduct if it demonstrates a pattern of behavior. And here, that pattern of behavior was one of emotional abuse and intimidation, not just against mom, but against the older daughter as well. And not just committed by father, but also by the paternal grandmother. Those are the things that the court was persuaded by, though that conduct is what informed multiple aspects of the best interest analysis. And all of those things led to a finding that not only was not against the great weight of the evidence, but was, as the court stated, clear and convincing evidence that these children needed to be with mom. Let's talk about her statements regarding domestic violence. And also throughout her argument, Sister Counsel kept using unequivocally proven when what she was saying was actually things that her client had said on the record that were contested. There were very few things that were unequivocally proven in this case. One of them was that both parties said that mom put her teeth on dad in some way, shape, or form. But it was not that she had bitten him while driving in a car before. It was, she admitted that at some point they had been having a flirtatious moment and she had grazed him with her teeth. And he said that when they got in a fight in the car, he was worried she was going to bite him again.
We really need to have to get into this stuff.
I didn't want to, Your Honor, but she raised it.
Let me finish. I don't think this is relevant. Let's move on.
Okay, I'm happy to do so.
This is
So
ridiculous.
we've read everyone's briefs and are familiar with what's in it. So if there's anything that could supplement that or respond directly, that'd be, I think,
Sure.
more useful today.
Then I will focus less on the facts and more on the law. I want to talk about Sabatine for a moment. Sabatine was decided 10 days before this opinion was released. And even though it was a very recent decision when the opinion was issued, it is clear that the judge in this case adjusted his opinion to reflect Sabatine's ruling. On page 12 to 13 of his opinion, the judge makes his established custodial environment findings. Admittedly, a large portion of that has to do with the household dynamics prior to separation. But on page 13, the judge says after the parties separated, the plaintiff initially took the children with her to Canada, where she remained the primary caregiver. And then there's a footnote that goes through all of the ways that she maintained that primary caregiver status during litigation. This is not a Sabatine error. This is a judge who is very much on top of the law and made adjustments to comply with a new change in the way these analyses were made. I can get into a lot more. Certainly, Sister Counsel got into a lot of the details. I would just encourage this court to consider these things, consider the best interest analysis in light of father's established pattern of behavior towards mom and towards the children. I would encourage the court to rely on Brown versus Brown and the fact that this kind of intentional emotional harm and intimidation is domestic violence. He had been doing this to mom since she became pregnant with the first child.
We're going to
And-
get into it, aren't we?
I can't help it, Your Honor. I feel very strongly.
We have the.
We've read the record, counsel. We know exactly what happened or what's alleged.
Right,
to have
and we
happened.
have the recordings.
Yeah. So
Well, in that case, you've told me to sit on it, so I will sit on it.
I appreciate it because sometimes people don't believe we are actually familiar with the facts and the law in these cases.
I do believe you're familiar with it. The fact is that this is one of the worst cases of coercive control I've ever been involved in, and I feel strongly about it. And so that's why I ended up getting back into it. I apologize, Your Honors.
Any final questions?
I don't have.
I don't.
Well, thank you.
Thank you,
I
Mr.
believe we have a few minutes for rebuttal.
I will be very brief. To the extent that counsel indicated that this isn't a change of custody case, well, this matter implicated the children's established custodial environment. And maybe change of custody is not the correct word, but the reality is that this move impacted the child's established custodial environment. And because of that, mother was required to demonstrate by clear and convincing evidence that this move was in the child's best interest, or in the children's best interest. And I don't believe that she met her burden in that regard. Finally, with the issue of attorney fees, I did want to point out that in the initial divorce proceeding, the trial court had imputed $30,000 of income to mother, but yet it also didn't consider that when it ruled on mother's motions for attorney fees and instead accepted her statement that she was unemployed. So that was clearly an inconsistency. And thank you for your time. And I always know that everyone is well prepared. Sometimes with Judge Ackerman, perhaps overly prepared. Just kidding.
Thank you both.
Thank you.
All right, thank you. Thank you both. As well briefed. The matter has now been submitted. We now call the final item for our 10 a.m. docket that is gone into well into the 11 o'clock time period. Item number 6, docket number 372-215, Corneal v. Corneal.
Good morning, Trish Haas.
Your day, Ms. Haas.
It is my day. I actually spoke to Mr. Zimmer and said, please don't do this to me again. So the last case hopefully will garner more of your attention and interest than the first two, because this really is an issue that really hasn't been addressed in any Michigan case law. We have a situation, the main issue is with regard to the trial court's determination of spousal support in this 22-year marriage. And the thing that is probably the most glaring error, in my opinion, is the court's reliance on my client's sexual preference with regard to making a determination of fault. That was a clear legal.
What should the court have done, right? The court simply said, your client indicated to his spouse that he's gay. And that's what the court said. And that's what your client said. How is that in any way impact his civil rights? That's why the marriage ceased. The wife testified, hey, if he didn't tell me he was gay, we'd probably still be married.
Well, there's a couple of reasons for that. First, obviously, that she didn't file for divorce until a year after the revelation was made. And to the extent it wasn't, so here's the
Didn't
situation.
that have to do with the child finishing
Right.
high school?
They agreed, right? They sat down and they said, okay, we're not going to stay married, but for purposes of this child, right, we're to Judge Ackerman's point, we're going to allow the kid to go through school. I mean, we take very seriously allegations of judicial bias, and I don't see anything here that would even come close to judicial bias predicated on your client's sexual orientation. So why would I be wrong in that assumption, in that assertion?
Well, the problem is, though, that she found fault. Okay. Now, to find fault, there has to be something that is a measurable impact on the marriage. Perhaps like, for example, we're a no fault divorce state. So if somebody says
But she's required to find fault. Once she goes through the factors, one of the factors is, what's the reason for the breakdown of the marriage, correct? That's factor 12, if I'm not mistaken. And the court says it's because he's gay, which is exactly why they got divorced. So again, had the court said, I'm going to order attorney's fees in this case because you're gay, or I'm going to do something based on your sexual orientation, I would agree. But what I'm suggesting to you is, this is a matter of mathematics in my mind. I don't see any evidence of bias whatsoever. Now, maybe my two colleagues do, I don't know, but I don't.
well, and I appreciate and respect your opinion, but my argument goes beyond that. The issue is that when you're assessing fault, just like fault could not be assessed if a party announces, we're a no fault state. If somebody announces to their husband, I'm not in love with you anymore, and they want to file for divorce, the court does not assess fault for that.
Yes, they do. They assess that as that's the reason for the breakdown of the marriage. Now, you're calling it fault. I don't know that that's the precise legal term I would use, but the question is, why is this marriage no longer? And the answer is here, because your client's sexual orientation. It's that simple.
Well, but the problem is that fault, and the court is required to make a determination about the breakdown of the marriage. But the court went further and assessed fault when it was determining.
Where did the court say I assess fault?
I'd have to grab the opinion.
I mean, you can spend as much time as you want on this issue. What I'm trying to tell you in a nice way is, this isn't what I would rely on to get to where you want to be, because essentially what we're talking about here is not whether your client was going to pay spousal support. He admitted he volunteered to pay spousal support. The issue is the amount of spousal support and the length of spousal support.
And I agree with you, but since the court did make an outward determination that it was assessing fault when awarding.
It did, but it didn't, in my opinion, and I'm just gonna leave it at.
Okay, well,
In
okay,
my
will-
opinion, let me finish. Fault had nothing to do with its award of attorney's fees. Nowhere in its ruling did the court say, and I'm assessing attorneys, or excuse me, spousal support because you're gay. So you can keep arguing it if you want, but I don't know what good it's gonna do you. So let's get to the numbers. The numbers are your client, and for somebody who had it out for your client, the trial court seemingly took his highest income earning year right out of the equation, right? So the way I look at it, your client, the way the court did it, did the math, was earning $198,000 a year. And the mother in this case was earning $40,000 a year. So that's a difference of $82,000 a year, right? So even if I do the math and I take away from your client the $3,500 a month he's paying in spousal support, and I give it to the plaintiff, your client's still $4,000 more a month.
well, respectfully, Judge Barello, you're not taking into account the tax implications. And under the IRS regulations, my client is the one that pays the taxes on the spousal support award. So given his income bracket, there is a
So
significant.
you're saying it should be less, not that there shouldn't be spousal
No,
support.
of course not, that the duration is too long. To me, it
So
was
how long should it be? A year, 2 years?
what it should be on a 22-year marriage. I would say no more than 7 years. 7 years would be the utmost.
Okay, how much should it have been? The 1,500 or whatever that your client said?
Yes, $1,500 a month.
Okay.
Mother had the ability.
So we're here over $2,000 and 8 years, right? That's where our disagreement.
Yes,
Okay.
which is a significant amount of money.
Yep. Okay, just so we understand, that's where we're at.
Yes, yes.
So tell me why other than, let's leave the sexual orientation stuff for a second. So now tell me why the trial court, we need to reverse the trial court on this award of spousal support.
Well, the duration of the support is too long based upon the length of the marriage. The trial court didn't take into account.
Is there a particular formula that we should use for how long it should be based on the length of the marriage? Is that all we look at? Do we look at other factors as well?
Well, you look at other factors as well, but mother here was employed part-time. She had the ability to work full-time. She had the ability to earn more income. The trial court seemingly didn't take that into consideration.
Well, again, how I read the record was the court did take it into consideration and said she hadn't been offered a full-time position, and two, given her age and given the amount of time that she had been away from being employed, it was unlikely for her to be able to either go back to school or to gain employment that would come anywhere close to what your client was making.
But she did testify to the fact that she was offered full-time employment and turned it down. So there was
But it was
evidence.
the same amount of money.
Well, if she was working more hours when she was paid hourly, it would have increased her income.
Her testimony was it was the same amount of money. So what difference? And essentially her employer treats it as full-time. But let's say she made 10,000.
Well, would it affect the amount of spousal support? I mean, $3,500.
By how much? In
Well,
your opinion?
in my opinion, perhaps $1,000 a month at a minimum.
I mean, see how this isn't, I mean, we don't have that, we're not litigating this, right? You
No,
have
but
to
it
show
can-
me
But it be,
major error here, and
well,
I'm
but
not seeing.
it fell outside the range of what was a principled outcome in this case. To pay spousal support for 11 years on a 22-year marriage when wife is educated, that to me falls outside the range of principled income, principled
It
rules.
didn't to the receiver that the court had appointed,
I don't believe there's a receiver in this case, Your Honor.
or an expert in, there was an expert, not a receiver, excuse me, an expert in spousal support and things like that. Wasn't there testimony, wasn't there a testimony of an expert in this case that the court used? And in fact, the court adopted the expert's opinion, I thought.
I don't recall that
Okay.
in this case, but perhaps I'm wrong. My issue though is that the court didn't actually find what, father's income was, which is one of the factors in the spouse's
The
court.
court did, the court absolutely found what your client, I just got done explaining it throughout 2023 because he got 2 bonuses. I mean, you can't misrepresent the record. We, honest to goodness, we do read this stuff.
Well, I understand, but usually when I'm looking at a spousal support award, the court says this is what I find to be husband's income, and there wasn't a definitive finding on that. She didn't explain that she was disregarding his highest income year. But his bonuses moving
Where did I
forward
get the number 198 from?
from the opinion.
Okay, so
Yes.
there was a finding,
I-
right? That's a finding.
I guess, yes, it was a finding,
Okay.
but the finding was erroneous based upon his testimony with regard to what his future bonuses would look like.
I got nothing
No
more.
final
I mean, we understand the case.
Okay, I'll just reserve the remainder for rebuttal if there's no further questions.
Okay. Thank you. Noted.
Good, too close to afternoon, Your Honors. Kevin Gentry on behalf of the appellee. I'm also here on
Isn't there an expert appointed in this case?
Jacqueline Rosler, Your Honor.
That's
You're
what I
correct.
thought. And she came up with the 3,500.
You're correct, Your Honor.
Okay.
Um,
I was worried that maybe I was getting confused.
Not at all. In fact, it seems as though the court's got a great handle on this case, and since I'm here on 3 cases too, and like the court, I'm here at the end of the day, I'll rest on my brief unless Your Honors have any
Smart
questions for me.
idea.
I think that's a good idea. Thank
Thank you, Your
you.
Honors.
With that, I don't think there's anything for rebuttal. So with that, the matter has now been submitted. We've at 11:30.
I did misspeak and I apologize. This was my 3rd case.
That's fine.
I apologize.
Well, I didn't know either, to be honest. That's why I asked.
I
That's
just
okay.
have to say I apologize.
No,
You don't
no,
need to
no problem, no
apologize.
concern. There are a lot of facts in all 3 cases. We understand.
Yes, we know
the-
these are
So
factually
you'll
intense
see,
family
if you
law matters.
stick around for our next case, there sometimes could be a lot of things going on. So with that, I know it's 11:37, our 10 o'clock session is over. Would you like to take a brief?
I see Mr. Collier and Mr. Wynn are here, and before I hear them, I absolutely have to have a break.
We'll take a very brief recess. Thank you. Welcome back. We'll now start our 11 a.m. session at 11:50. I'll not repeat all my earlier instructions, but please remember that because these proceedings are recorded and published publicly online, counsel should not use the name of minors or other vulnerable individuals. We will now call item number 7, docket number 369895, Love v. Rudolph. And just to clarify, because we have tried making a table, we have some appellant, cross appellees, appellant. Yeah, so we're also going through 24 cases over 2 days. We are familiar, but if you could maybe refresh us very briefly at the beginning, because we only have 2 issues that I don't think are that complicated, but just state just to make sure sorry.
I know this is your first time, Mr. Collier. So.
Right. I just hope you don't think that after I've argued.
Only my second time in this seat.
Right,
So.
right.
Yeah.
Well, I can tell the court that counsel conferred before the argument and came up with a bit of a game plan, if it pleases the court. So there's the 2 issues, as you said. There's the issue of priority under 3114. And then there's the issue about the 3rd car. So what we thought we'd do is address the first one. I'll argue, my 3 colleagues will respond, and I'll reply, and then turn to the cross appeal, if that pleases the court.
That's fine with me.
Okay. My name is Trent Collier. I represent Auto Club and LaShawn Rudolph. I'd like to reserve 5 minutes for rebuttal. I largely I want to rely on my brief, except for, sometimes you read the briefs and realize what you didn't do as well as you wanted to do. So I wanted essentially to give the court kind of the most simple version of our argument here. Everyone,
Now,
I
are
think.
you dumbing it down just for me?
Oh, no, not at all. This is how I go through life, Your Honor.
She didn't pick the box.
Right.
Isn't that it? She didn't.
She didn't pick the box number 6, if we're talking about PIP.
She didn't pick box number 6, but she did take an exclusion for herself. She listed herself.
Right.
Right. So that's the first step. I think all counsel will agree that under 3109A, Ms. Rudolph excluded herself under the policy. That's the first step. This leads to MCL 531.14. This policy states that if there is an exclusion that applies to the policy, then that policy is essentially taken out of the mix. It doesn't say if there's an exclusion that applies to the plaintiff. It doesn't say it has to apply to the accident. The question is only whether the exclusion applies to the policy. That's the plain text. And I don't think anyone can say that Ms. Rudolph's exclusion did not apply to her policy. That's exactly what it applied to. So therefore, under MCL 531.14.6, she cannot be in the order of priority under subsection 5. And I think what you'll find is what my colleagues are going to argue is that, well, it didn't apply to Mr. Love. It didn't apply to this accident. It doesn't have to. Under the plain text, it only matters if the exclusion applies to the policy. And it's important to note that the 3114 doesn't say the exclusion. It says an exclusion. Any exclusion is enough to trigger this under 3114.6. And we have all those elements here. So that's really the simplest version of our argument. She took an exclusion. So there is an exclusion that applies to the policy. There are some arguments about 3107D. I think everybody concedes that that section doesn't really apply to us because it applies when there's Medicare, which is not really what we have here. So it's really, in my view, reconciling 3109A with 3114. And so that's how we view it. And I've shared how we address that issue.
But she didn't bite anybody.
That we know of.
That we know of.
Yeah. I don't know. Yeah.
Sorry. Mr.
That's okay. That's okay. I mean, it's good to point those things out. Yeah. So I don't want to beat a dead horse here. That's our core argument. If the court has any questions.
I have a quick question, and again, if I'm mistaken about the law, which I know you have no problem letting me know, but there's and I candidly didn't know this until this case. There seems to be a special statute dealing only with motorcyclists in this. Does that in any way impact your theory of what you just gave to us?
It does in this sense. There's a well-established rule in Michigan jurisprudence that if there's a general statute and there's a specific one, the specific one prevails over the general one. So, you're going to hear my colleagues talk about, well, this is a car accident, so therefore 3109 applies. It doesn't, because that's the more general one. We have to look at the one that applies to motorcycle accidents, which is 314.6 and 314B 5. And it's also more specific because 3109 deals with just what the insurer provides to the insured. 314 deals with what happens to the policies between insurers? That is the specific issue before the court.
Thank you.
Sure. Any other questions?
No, thank you.
Thank you.
Always appreciate your briefing and your arguments, counsel, very much. Thank you.
Good morning, Your Honors. Keith Bank appearing on behalf of the plaintiff, Walter Love. This question turns on the use of the word apply in both 31146 and in 3109 sub A1. If you look at 311.
Sorry, counsel, 3106 and 3109.
Actually, 3114 sub 6. That's the motorcycle priority
Yep,
or the
okay.
exclusion. And that says that an insurer is not in priority if an opt-out, the Medicare opt-out, or an exclusion applies. Now, it doesn't say under a policy applies. It doesn't have the language that he's arguing it has there. It just says, does an exclusion apply? You're not in priority. Well, the question is then, does an exclusion apply here? And if you go to 3109A sub 1, it clearly says that exclusions under this 3109A.
Oh, I thought you said 3901. That's what threw me. It's 3109. Okay.
3109A.
I'm
And
sorry.
it says that these exclusions, like Ms. Rudolph chose, only apply to the people specifically excluded or within their household. So when she made the exclusion, it was only applicable to her. So the policy, and that's what 3114 talks about, is the policy. The policy does provide coverage, right? It provides 250 in PIP coverage with an exclusion. That exclusion was only given to Ms. Rudolph, and under the statute can only be given to Ms. Rudolph and apply to people in her household. And the reason for this is when they enacted these statutes, they wanted to transfer the responsibility from no-fault insurers over to healthcare insurers, right? And to safeguard that, they wanted to make sure people who were insuring themselves had healthcare. And so there's this process where you have to verify you have a qualified healthcare coverage, you have to verify it, then they can issue this 250 policy with an exclusion. So it's shifting over to healthcare. Well, with a motorcyclist, you can't do that because you can't sit there and vouch for a motorcyclist that you're going to hit in the future. You can't vouch for whether they have qualified healthcare. So you can't opt them out of coverage by the statute. So the statute makes it clear that when you have, and I'm sorry, I'm using my language a little imprecisely here. Opt-outs only apply in the Medicare context. They're only if you're a Medicare recipient under Parts A and B, then you can completely opt out of all PIP with the $50,000 option. If you don't have Medicare, you have to take the 250 option with an exclusion, right?
What about if you have Medicare? I'm asking for a friend here. What if you have Medicare, but you still have health insurance? You can't opt out then either, can you? You have to have parts A and B in order to, or part A, is it?
Part A and B, I think you can completely opt out.
Can you, if you
Yes.
just have Medicare, even if you?
Yeah, if you have
Okay.
Medicare A and B and like a supplemental to go along with that, I'm confident that you can opt out completely from PIP. But
What if I'm Judge Ackerman, clearly not up to Medicare age like maybe some of us are? Could he opt out if he has insurance completely?
he can't opt out. What he can do is choose the 250,000 option and then exclude himself, right? So he
Can't exclude me.
can exclude him and people in his household.
Right, but he
Right.
can't exclude, assuming
can't
we don't
exclude the
live-
rest
we
of-
don't live together.
He can't
And we
exclude.
don't, for the record.
Yeah, you can't exclude the rest of the universe, and that's because of the statutory language. And that's the statutory language that says that the exclusion must apply only to benefits payable to the person named in the policy, the spouse, resident relatives. So you have the statutory breaks on there.
Is that why, and I'm actually getting to something here, believe it or not. Is that why option 6 exists in this policy then?
Option 6 is the Medicare complete
Okay.
opt-out.
All right.
And Ms. Rudolph couldn't choose that here because she was not a qualified person who could take the $50,000. But since she had QHC, she could take the 250 option, and that's what she did. But the statute then says, well, you're only excluding yourself, and this policy will apply to the rest of the universe.
Now, my last question, and then I'll leave you be, is the one that I asked brother counsel, and that is the statute dealing specifically with motorcyclists. Seems to me, and please correct me if I'm wrong, to suggest that if it's a motorcyclist, you have to pay PIP benefits. Is that your understanding?
Yes, there's a motorcyclist can be excluded from PIP if they don't have liability on their motorcycle. There's a minimum insurance requirement for motorcycles, and that
Okay.
that can get them disqualified. But yes, if you're a motorcyclist in Michigan and you're hit by a car, you do get PIP from somewhere.
Okay. Thank you, counsel.
And just to sum everything up, it's a fairly straightforward application. The question is, does coverage apply under these circumstances, right? And that's what 31146 says. Does coverage apply under these circumstances? If it does, they stay in priority. If it doesn't, they get out. Well, does it apply? We look to the 3109, the statute that allows these things to happen. Well, it says, no, it doesn't apply to Mr. Love. It only applies to Ms. Rudolph and people in her household. So therefore, they should stay in. AGCI should stay in as the insurer of Ms. Rudolph's vehicle.
My understanding that Mr. Collier's family is somewhat at odds with them because he has a proclivity of reading insurance policies to them whenever they get together. But I make the point, the humorous point, only because he's somebody who obviously knows this stuff inside and out. So if you were to say to Mr. Collier, you're wrong in a sentence, what would you're wrong in this case because?
Apply means applies. The coverage applies under these circumstances.
Thank you.
Through the statutory language, the exclusion only reaches Ms. Rudolph and her family. So coverage applies. They can't use 31146. And
Any other
rest and
questions?
allow.
Thank you very
I'll keep
much. I
going to counsel.
appreciate those clarifications.
Hey, you're
Just,
welcome.
I mean, obviously you were sitting, we go from, this stuff, it's Greek to me and I'm Sicilian,
Oh,
so.
and I know with, in this case, we're dealing with a typo in the law and all that fun stuff too.
Yeah,
So,
yeah.
so
A Scrivener's error.
thank you.
Yep.
Good afternoon. Joy
What'd you
Glover.
bring for lunch?
I did not bring anything, so
Now,
I'm
sit
sorry.
down.
Joy Glovic, I'm the attorney for Citizens and Hanover. We were also the cross appellates. I concur with plaintiff's counsel's arguments in terms of the issue with respect to the opt-out issue.
Can I ask you, counsel, do you, and if you know, fine, if not, don't, no big deal. Do you know if your clients offer similar language that we find in this case in terms of the
Yes, they all, I mean, most insurance company follow the same kind of, I mean, if you look at your own, there's the options for the coverage opt-outs, they have the selections, option 1, 2, 3, 4, 6. They all have similar language. It has to be approved by DIFAS to be submitted to insurers. So
it's essentially standard industry wide then?
I believe so. I don't think there's much difference of any because I mean, the option for all of them that I've seen say, the people excluded, you have no insurance coverage for anyone else, there's 250,000 coverage. So if that exclusion under 310A2 was only basically applied to everyone as Auto Club is arguing, then I mean, that option has no real, it doesn't make sense because if everyone else has $250,000 coverage, but everyone else is excluded because of that election, there wouldn't be coverage for anyone. I mean, 3109A is an election under 3109A is different from one under 3107D. Like we've discussed, 3107D is one under Medicare. The statute under that section, subsection 5, says that an election under the section applies to the applicant or named insured, the applicant or named insured spouse, or relative of either domiciled in the same household, and any other person who would have a right to claim benefits under the policy for the election. 3109A does not contain similar language. It specifically said it only applies to benefits payable to the person named in the policy, the spouse of the insured, and a relative of either domicile in the household. It doesn't contain the global language like 3107D has. Then when we go to the motorcycle priority statute under 3114.5, and then the possibility for exclusions under subsection 6, which discusses the differences under 3107D and 3109A2, it doesn't say, it mirrors the same thing that those sections reflect with respect to one being applied to everyone who could possibly claim coverage, and the other one limited to the person electing the exclusion or people in their household or a spouse. 3114.6 says, if an applicable insurance policy in an order of priority under subsection 5 is a policy for which the person named in the policy has elected not to maintain coverage for personal protection insurance benefits under section 310D, or to which an exclusion under 31009.2 applies. If the legislature just wanted to say, if you've elected either one of those under 3109A2 or 3107D, you're out, period. There would be no sense to have that other thing, or as to which an exclusion applies. They are clearly limiting it to the same language in 3109A, which means it has specific limitations on who it applies to. It applies to the named insured, the spouse, a resident relative. It does not apply to everyone in the universe. It can't by the statute's own terms, and that section mirrors it. That same language is in another section of 3114 under subsection 2H. It says the same thing. It's very intentional language that differentiates between the effect of 3107D and 3109A. That's what we have here. Ms. Rudolph was not in the accident. The exclusion does not apply to her in this accident. That election, the exemption under subsection 6 of 3114 doesn't apply in this situation.
Is this an issue of first impression? Is that what I'm hearing?
I'm sorry.
Is this an issue of first impression? Is that what I'm
Yes,
hearing you say?
I believe it is, Your Honor.
So-
I'm not familiar with anything.
Is anybody here requesting that it be published?
Only if you win.
Well, I mean, it is what it is. I mean,
I appreciate that answer.
we all have, I mean, that's the world we live in. We make our
You
arguments.
just want to know what the rules are, right?
Right. I mean, how can we do our best to apply what we believe is the wording of the statute and how it should be applied. I do believe that Judge Snow in the circuit court got it right. I mean, the exclusion, when it's an exclusion on 31A2, doesn't apply to this situation. Auto clubs in.
Thank you.
Okay.
I note, Mr. Collier, it takes 3 of them to.
I appreciate all of you showing up today with the weather that we had coming in. We all had our drives and thank you for being here.
It was a good drive from Grand Rapids, I'll tell you that.
Oh,
So,
no.
Anyway, Your
I'm
Honor.
sorry.
No, it's perfectly fine. And it's going to get worse because I'm just Dave Perangela here for Farmers. I'm not going to be able to state it any more eloquently than my co-counsel have. So unless you have a specific question of me, I'll sit down.
I think I understand it now.
We
Okay.
get it.
Thank you, Your Honor.
Thank you.
Just a very few brief points in rebuttal. The court heard a couple of times, this policy doesn't apply to this person. This policy doesn't apply to that person. Under the statute, that is not the right question. The question is whether there is an exclusion that applies to the policy. It does not consider the person. So it is not relevant whether it is this plaintiff or any other person. And here's one way to know. When I started practicing law, I clerked for Justice Robert Young. And one of the first things he taught us is how to diagram a sentence. So if you diagram the sentence in 31146, you will see that the word applies to the policy. The question is whether the exclusion applies to the policy. That grammar is controlling here. We cannot look at who benefits from this. We can only look at whether there is an exclusion. And for the reasons I've already said, we believe that there is. I guess I really don't have anything else unless there's more questions from the.
No questions.
I don't.
Thank you.
Thank you.
Moving on to part two.
Moving on to part two. Again, Joy Glovic, First Citizens in Hanover's, we filed a cross appeal on the basis that the circuit court did get it wrong as to our motion for summary disposition as to Citizens Insurance Company Midwest was the insurer of Unit 3 in the
The
accident.
woman who pulled over.
Yes, the woman who pulled over.
And then
And the
was-
issue is under subsection 3114.5, it has to be a person involved in the accident. And the issue is according to, well, I mean, it's the burden of proof to prove she was, we don't have to prove she was not involved in the accident. Somebody needs to prove she was in fact involved in the accident.
So another car struck her and then the chain.
Then another vehicle struck her. She didn't, it's important to note, Unit 3 did not continue on and hit another vehicle. It's not like there's other cases where.
But it hit her and continued on.
Right, exactly. The damage, the hit is, very minimal. The damage to the vehicle is basically some scratches along the side. The vehicle that hit her continued on to hit another vehicle, which then hit Mr. Love, or at least that's what we gleaned from the police report, which is basically the only thing we can get in terms of how the accident occurred. Nobody else can testify as to who actually hit Mr. Love, who, what vehicles were otherwise involved, but, there's no active involvement in terms of Unit 3 contributing to the accident, causing somebody to take some action that actually then hit another vehicle. Unit 3 was hit by another vehicle, did not hit anyone else. It's undisputed, did not hit Mr. Love. So the issue is, how can it be involved in the accident and be responsible for benefits when all it did was be hit by another vehicle that then went on can continue to hit someone else? So it's our position that this summary disposition should have been granted, and the insurer of Unit 3 should have been dismissed from both plaintiff's claim and farmer's cross claim in terms of the order priority for benefits for the accident.
Any questions?
Nope.
No.
Okay.
This case was very well briefed. And here's a hint, we read the briefs.
I didn't get that.
Just like Mr. Collier reads insurance policies, I read briefs to my family members.
You too?
Mostly insurance briefs too, I would add, because they're the most exciting. That and eminent, or not eminent, adverse possession.
Keith Bank appearing again on behalf of plaintiff Walter Love. Thank you for the compliments, Judge Borello. We appreciate
Oh,
that.
that's true. It was very well done.
But I think this is a good old question of fact that needs to be resolved by the jury. Her involvement was a little more than defense counsel let on. Immediately before the collision, their insured testified that she brake checked. And then
Somebody's coming up on her, right?
yeah, and then she saw him.
Probably me.
Just glad it wasn't me, but yeah, she testified that she basically brake checked him and then swerved. She sideswiped the striking vehicle, sideswiped Hanover's insured, and then went into the pile.
Right.
So there is a little more than just passive involvement here. And if you look at kind of the cases, you do have cases that say brake checking equals involvement. So you do have a line of cases that allow this to reach a jury. And I think probably that's the best where this should be is at the jury.
What then would your analysis be different if she was just parked on the side of the road and got hit, that she had for some reason pulled over or whatever minutes before any of this? Would your analysis still be the same?
Absent that brake check, my analysis would not be the same. the active idea. And, we don't know enough about the physics of the accident to know how much there was deflection off her into the vehicle. But, there could be an argument if, she deflected the person somehow. But I think in this instance, you have the brake checking and the bounce off the vehicle. And that seems to be enough to get at least a jury question on involvement.
Thank you.
Thank you.
In terms of the whole brake checking issue, there's nothing to support that brake check had any impact on any action that the drivers took that with respect to the action. So she checked her brakes. There's nothing that the other drivers did something
Factual
different.
dispute as to whether it, what impact it had, considering she was hit and then they hit someone else.
It could be if somebody said, something, an affidavit from one of the drivers or testimony from one of the drivers, I saw the brake light, it's caused me to do this, this, and this, or this and this. There's nothing. So she brake light, there's nothing to support that it had any impact on anything that any of the other drivers did. There's also, basically it's just speculation and conjecture as to what impact that had on the other drivers, and that's not permitted to create an issue of fact. There has to be something concrete and substantive to support, create an issue of fact. And there's nothing, all that we're doing is saying, well, it could have had this impact, or it could have had this reaction, but we don't know if it did or did not. And that's not enough to just say it could have to create an issue of fact. Whether or not the vehicle changed directions, it's speculation. We don't know. There's nothing to support that.
The moving party had a responsibility to come forward with some evidence, and they failed to do so.
I'm the moving party.
I'm sorry, that
the non-moving party
that the
came, yes.
non-moving party-
The non-moving party has an obligation to provide
Create a
evidence
question.
to create a question of fact. You can't rely on speculation and conjecture, which is all we have here. So that's where the issue is. If there would have been
But isn't
definitive
it more
testimony.
fun, really?
But I'm sorry?
Speculation than facts. I mean, come on.
Right.
Give us some.
It is more fun, I agree, but we are in the world of law and we're bound by certain obligations we have to create our cases or defend our
And the
cases.
fact that the non-moving party failed to introduce anything either by expert testimony or, as brother counsel alluded to briefly earlier in his argument, the physics,
Driver,
we just, right. We
what are the
don't
other
know.
drivers?
Right. We just don't know.
We just don't have it. That's the whole point. There could be any number of things that could have happened, but there's nothing to support what actually happened or what they're arguing happened.
Where are we in this case? I mean, I don't recall how far along is discovery closed?
Discovery's closed. We would
Okay.
be going to trial.
All right.
It's currently stayed pending the decision. in the Court
So,
of Appeals.
so this isn't something that could come about in the future. The record is what it is.
It'll come out at trial if it goes to trial because there's no discovery remaining. So.
Thank you.
Any final?
No, but thank you for that
Thank you.
those clarifications.
All right, with that, the matter has now been submitted. Thank you all.
Thank you. Thank you.
We'll now call item number 8, docket number 372894, Pellet v. State Farm. We'll do that. After this, I'll do. Jump back. Should I? All right, we'll do this and then I didn't notice that.
Yeah, I just noticed.
Okay, we'll do 10 and then 9.
Before you begin, Mr. Wynn, I got a bone to pick with you. I am a hockey fan and I watch every Red Wings game. And do you know what I hear on every single broadcast of the Red Wings game? Your firm's logo over and over and over and over. Now, I'm wondering, is Figer worse than Geico? Or is Geico worse than Figer? You guys got to get a new tagline.
I think you got me mixed up with someone else.
I'm joking with you.
I was gonna say,
yes.
I'm like,
I am joking with you. Anyway, it's good to see you again.
good to see you. Good to see all of you, actually. Jared Reardon appearing on behalf of the plaintiff appellant, and I just got to get this out of the way real quick. To the best of my knowledge, my client did not bite anyone. And I will concede, neither State Farm nor its agents bit anyone either, to my knowledge. Just got to get that out
Do
there.
you have an affidavit though, counsel?
Oh, there might be a little procedural deficiency with that in that case.
That was funny. Thank you for that.
That was so
Needed
good.
that.
Yeah, and hopefully this is
No.
definitely a less complicated case than the previous one. I think it's actually a pretty simple case. It's a simple case of statutory construction and the trial court simply writing law that is not contained within the statute.
It seems to me that where we have a statute that's as clear as the one at issue here, which I believe is 3020 or
Yep.
something like that. I'm just curious what your initial reactions are though. Can I and the insurance company change the way we decide to communicate with one another?
That's an excellent question, and I think reading the statute, the answer to that is no. You can, I believe, you can supplement the mail notice with electronic notice, provide it sort of as a secondary means in case the mail never reaches you, for example, if you're afraid of that. But it's an explicit requirement in every insurance contract issued in the state of Michigan that this provision be included, requiring notice to be sent by mail to the insured's last known address.
So it's similar to what we classify in criminal law when the United States Supreme Court issues an opinion on a particular constitutional issue. We typically say that creates the minimum.
Yes.
And here your contention is at a minimum, the statute says X. Now you could supplement it, you could go beyond that, but at a minimum, you must do this if you're the insurance company. Okay.
Yes,
I
couldn't
think
have said
that's
it better
an
myself, frankly. You can supplement it with electronic notice, but the fact that this is a broad requirement for any insurance contract to issue in the state of Michigan shows that the legislature intended this to be a core protection for insureds, and that because of that, it cannot simply be abrogated by agreeing to electronic notice only. Perhaps it would be wise for the legislature to do that, but that's ultimately a legislative initiative and not an initiative of the court. And
These are the commandments, right?
these are the
Written that
commandments,
numerous
exactly.
times, right?
The four commandments, or the three commandments, I believe the fourth one is just a subsection not dealing with anything at issue here. But so in essence, that's the argument. I think it's a relatively simple case of, and the trial court outright admitted at points that it was ruling in contravention of the statute. At one point, I believe it's on page 10 of our brief, we quote, the trial court said the statute did say written notice. It says written notice by mail, but he opted out of that. So the trial court is acknowledging that the statute says what it says, but it's ruling against it anyway, because the trial court found it would be, quote, that electronic notice is, quote, the way of the 21st century. Again, would it be wise for the legislature to amend this provision to allow for electronic notice to instead of notice by mail? Maybe it would, but that's not the province of the
Right.
courts to write it in.
Like the statute says what it says right now, and it says pre-post is paid.
Yes,
It indicates to me physical mail.
exactly.
And there's no dispute, correct, that they didn't comply.
There is no dispute that they did not send it. Well, there is a dispute as to
Most
whether they,
recent address.
the most recent
Right,
address,
right.
that's the dispute.
So it really takes, probably a better question for other council. How long to,
Over a month.
yes, enter a correct address?
I don't believe it should take that long, but
I
sister council can answer that question better than I could,
Right.
but I don't think
I was-
intuitively
I
it should
was
take a month.
shocked that it would take that long.
Yeah, And there's no dispute that they sent it to his previous address, and there's no dispute that he told State Farm through its agent, Mr. Curtis, that he was updating his address. So that's pretty much all I have on this issue, and I will address the collateral estoppel issue briefly. First, I'd just like to say this is not an issue the trial court reached, so this issue is really ancillary to the appeal. And second, I would say,
You know, I don't think you have to go there.
oh,
I really don't.
okay, well,
That well, maybe I'm just.
I
speaking-
concur.
Maybe I'm just
Excellent.
speaking for myself.
There's
You are
three.
correct. There are questions here that we don't know the answer to.
Right.
perfect.
To
Well,
be able to decide that.
in that case, unless you have any other questions, I will give it over to sister counsel, and I reserve whatever time I have left for rebuttal.
I very much appreciated the straightforwardness, first of all, of your argument today, but even more importantly of your briefing. Because again, you know, people forget, we hear all manner of cases. And I'm not an expert by any sense of in anything, much less these. So I really do appreciate it because sometimes counsel who typically deal in these areas will talk to one another.
Mhm.
And I always did what my father, who was a lawyer, told me when I asked him, well, how do I write a brief? And he said, write it as if a second grader's going to read it, because that's who's going to read it. We call him judge.
Impressive qualifications for a second grader, honestly.
Yeah,
Respect it.
you know, and he became a judge, and I would often bring that quote up to him as well. But it does make a difference. And I mean, people, unfortunately, in law school, there's in my opinion, way too much emphasis on the oral argument. We spend a lot more time with your briefs than we do here, obviously, and you can tell we've got some idea of where we're going to go. So it really does make a difference, and that's why I'm very appreciative. So thank you.
Thank you so much. I appreciate it. And I will hand it over to defense counsel now.
Good
So
morning,
Afternoon.
afternoon, Your Honor.
the statute in that cause-in case seemed pretty clear that it needs to be mailed. So do you have any, response to that in particular?
Yes, Your Honor. Lauren Hagerman representing defendant Eppley State Farm. I want to largely rest on my brief on that issue. I think, State Farm's big contention there is he opted out of that with the text message, and the facts on that are what they are. The circuit court.
Well, can I just tell you, cousin is pretty much on point here. So I'm just shocked that was the argument below, that you can opt out when it makes clear that you cannot. And we are bound by that. Now, whether you want to go to the legislature and ask them to change this, the reality is, I think all my bills are paid electronically at this point. And whether they want to give this notice and whether there's some argument here that he had actual notice, I have to admit, initially looking at this, but when I read the statutory language and cause-in, certainly your client was familiar with these concepts, and yet you brought this to the court, and that is not what the law supports. And as far as collateral estoppel, was this the one where they filed in two
That's the
different?
other side.
Okay,
Yeah.
oh, that was the other one, okay.
No, that is this case, but it's the other side.
Okay.
Yeah.
All right, well, that also was an issue for me, that there was filing in two counties at the same time. I don't know how you sign when you're at the clerk's office, that there was no, well, I guess hypothetically, to your knowledge, no other suit is being filed, but I didn't know, those things bothered me about this case.
Yes, Your Honor. And I think the one thing I'll hone in on reading the room here, and I'll be brief, is
We can read the statute and we can read our case law. So you can argue all you want that he can opt out. He can't.
And I just, getting to your latter points,
Mhm.
what I'd like to address is I think you've really caught on to something here, which is the collateral estoppel, and that
But
the reality is,
we don't have enough here to make that determination. At least in my view.
Well, Your Honor, the elements of collateral estoppel are that
It's factually intensive. You know, it has a lot of equitable value that we can't do as an initial matter at the Court of Appeals.
And we don't even know if that other case is over, right? I mean.
yes, Your Honors. So the underlying analysis regarding notice is factually intensive. But litigating those facts and whether the statute was complied with or not, that belonged in Kent County. And the court has the Kent County brief and the Kent County order. That was a UM case involving the exact same insurance policy. State Farm came forward and said, we've canceled this. We've sent notice of the cancellation in compliance with the statute. And this issue of did it go to the correct address, this factual question, did not come up in response to State Farm's motion in Kent County. Plaintiff had the opportunity to respond and say, hey, wait a minute. We don't think there's compliance here. We think there's a question of fact. But at that time, when State Farm filed that motion and put that before that court had evidence that the notice went out to the insured's last known mailing address, and that was it. And the court ruled on that and dismissed the case. And the order itself says there's no policy in effect. It's been canceled. Plaintiff did not respond, did not challenge that ruling, did not appeal that ruling, did not move for reconsideration. Plaintiff could have done all of those things. And even when State Farm raised this argument, by the time this got to Wayne County, State Farm filed the same motion in lieu of an answer. And the Wayne Circuit Court said, let's do some discovery. And when that first motion was filed, this issue again never came up. The question of did it go to the last known address was not brought up by plaintiff until after discovery in the Wayne County case. And there were more than enough opportunities for plaintiff to do that. And they didn't even need discovery. Plaintiff knows his address. They had the notice. He could have said, hey, this isn't the right address. And that could have been resolved in Kent. And that's really what State Farm is hanging on here, is that this should have been presented to the Kent Circuit Court. Kent Circuit Court should have had an opportunity to rule on this with those facts, and it didn't. It ruled based on what was in front of it, and that ruling was not disturbed. And that's the whole point of collateral estoppel, is that we're not disturbing these rulings. We're discouraging a lack of finality, shopping for forums. There was no reason that they did not challenge that ruling or pursue it further.
I believe you have a compelling argument here. I really do. And I don't think anything, if we declare that it's not right for adjudication, it certainly wouldn't preclude you from returning to the circuit court to make these arguments.
Absolutely, Your Honor. And I 100% acknowledge that. I do think this is a good case to consider rather than vacating and remanding if the court's inclined to find in plaintiff's favor on the notice issue, to affirm on those alternative grounds, though, because the facts relative to the application of collateral estoppel, those facts aren't disputed. In fact, this whole argument isn't disputed. There has been no response to this argument in any of the appellate briefing. There was not a response to this argument in the briefing in the trial court. So it's really not a contested issue, and certainly not a factually contested one. The laws of collateral estoppel are well established. So I do think the court has what it needs to undergo the collateral estoppel analysis. And if we went back to Wayne Circuit and kind of contravention of what collateral estoppel is designed to promote, which is efficiency, we're going to go back, ask for a ruling on collateral estoppel. The court's going to grant it, and we're going to be right back where we started before this appeal, just with more time and resources having been expended. Or if the court denies that, I would submit that's the improper result for the reasons set forth in our brief. Come back to the Court of Appeals. And so we're just dragging all of this out even further, when I do think that the court has what it needs in the briefing and in the record to make the collateral estoppel specifically determination. So I would just really request the court to consider doing that in this case and affirm on those grounds.
If I could go back to the initial issue for a second, you mentioned in your collateral estoppel argument, and again, I think I heard you correctly, that Mr. Pellet, is it?
I think so, Your Honor.
Pellet, that Mr. Pellet had waived, were those your words, that he had waived the written notice, or is it, I'm trying to fully grasp your argument here. Is it that he waived it, or is it that they mutually agreed to an alternative form of service?
The latter, Your Honor. I don't
Okay.
know if I specifically used the word waive.
I don't think you did, but
Yeah.
I don't know. I hear about every third word these days.
No, that was the crux of it.
So
but-
would it be your contentions, counsel, that in order, if we were to find that this requirement can be waived, you would not dispute the fact that it has to be at a minimum mutually agreed upon, do you?
No, Your Honor, I don't think I could dispute that. I don't see a way to make a proper precedent if both parties didn't agree to that. But in this case, you've got someone who did opt out, so I would submit that.
Now, when you say he opted out, and on this, I don't remember the record, so please help me. Was there a form that was sent from your client to Mr. Pellet? Or was it just between him and the agent of your company? I don't recall how that went down. If you do, fine.
Yeah, Your Honor, candidly, I don't have that developed on the
Okay.
record on that issue. State Farm came forward with evidence that he opted out based on its internal record keeping. There was no challenge to that. He acknowledged that he got the text that he signed up for them. But beyond that, I don't have the answer to that question. But
And one last, are you solo practitioner? Are you in a firm or?
Your Honor, I work for Slater Siebert in Troy.
Oh, so you're in a firm.
Yes.
So whoever gave you this case, you need to go back to them and say, hey, blank, blank, next time you give me a slam dunk, you go argue it.
I'm gonna plead the fifth on that. I'm gonna go have a drink after this and go move
Well,
on to
you've
my
done
next appeal.
you've done an excellent job for your client.
Thank you, Your Honor.
Surely have.
Thank you. I appreciate those comments.
And look, there's nothing stopping anyone from going to the legislature and saying, here was a situation that we had. This man clearly had notice. And to think that after not paying for three months, was it? That he was still somehow insured when the statute only requires a 10-day cancellation period that he have notice of. But you did also mail it, right? Am I wrong about that?
State Farm did mail it.
So, I mean, so clearly you understand that this is different, right? That apparently our case law requires.
Well, but Judge
So does the statute.
Judge Letica assumes that the insurance industry would have some sway over the legislature, and there's just hardly any evidence to support that at all.
No, I mean,
So, and then back to the beginning of this, how long does it take you to change someone's address? Seriously?
again, I don't have a great record on that, but the testimony was that it can take up to several weeks. But
Yeah.
I remind the court again, this is all argument that Kent County should have been presented with.
We get it.
I hear you on that, but as I like to say, and I know Judge Barilla disagrees with me, we are not a fact-finding court. And we leave these factual determinations to the trial court, and then
I enjoy fact finding personally.
If I could just make, I don't want to turn the tide, but the last thing I want to say is the court doesn't have to engage in, the fact finding should have been done in Kent County. Plaintiffs should have asked for an opportunity to do that fact finding, but remember, those facts weren't presented to that court. They didn't ask
Not
for
like
that.
Detroit. You seem to want to go to Grand Rapids.
Do you know, I have to drive there in a couple of months and I am really stressed about it. It's in
I don't
January
blame you.
and I am nervous about the weather and, no, I don't want to go to Kent County, but that court should have been given the opportunity to do the fact finding and it wasn't. And there was no reason, again, that plaintiff couldn't have said based on what it was presented with when it got that motion for summary disposition, hey, wrong address, we've got a notice issue here. That just didn't happen in this case.
Thank you very
Thank you
much.
very much.
we
Thank you,
fully
Iris.
understand.
Any rebuttals, sir?
Very briefly in rebuttal, I think we've done the notice issue more than enough already. But I would just, in a sentence, say there's also additional proof that they knew, and Judge Letica, you touched on this a little bit. They knew they had to do this because they did send it out by mail, despite purporting to argue that they didn't have to. that's clear evidence that they knew they had a statutory requirement to do so.
And their knowledge of what their requirements were is irrelevant.
It's irrelevant, but I think it goes to,
Yeah, absolutely.
everyone knows this is a requirement.
If you're asking us to give you equity, you have to have clean hands, right?
Yes. And turning to the collateral estoppel issue,
Well, do you want to address the point that the complaints were filed in two different counties involving the same action?
I can't speak to that personally. I wasn't involved in filing the
Well,
complaint, but
just like council has to go back, I
Yeah.
think you have to go back and say,
I too will plead the fifth on that one.
Yep.
But
okay.
I will say there's a key difference between this and the Kent County litigation, and
Mhm.
that's that we did not have as far as I'm aware, the motion for summary in Kent County was, as far as I know, and I could be incorrect, before the close of discovery. And we did not have the deposition of their agent, Kevin Curtis, who testified that he was informed by Mr. Pellet that he wanted his
Another
address
reason why we
changed.
should not engage in fact finding.
Yeah.
Okay.
Thanks
we
for
like
opening
having
that can.
we like having fun here. We like
Yeah.
we like speculating and we like fact finding. We're having fun. But that's all I would say in rebuttal.
Okay.
Thank you very much.
Thank you.
Thank you.
Excellent briefing. Thank you.
Thank-
The
both.
matter has
both.
now been submitted.
Oh, then I was wrong. I apologize. Then don't worry.
Yeah. All right, we will now call item number 9, docket number 372692. Harper v. Reed.
Good afternoon, Your Honors. May it please the court, Courtney Lavender on behalf of defendants Lorenzo Reed and GFL Environmental Services.
How have you been, Miss Lavender?
I've been good.
I
How are
remember you as a
research attorney.
yes,
Yeah,
you did an excellent
yeah.
job here.
Thank you. Thank you. I enjoyed it here a lot. Now
Despite what they told you about, I wanted you fired. None of that's true.
I don't hold grudges, so. Yes, fun being on the other side now.
How long
so.
have you been gone from here? Has it been a while?
Yeah, 3 years. Yeah,
Has it really?
2022.
Gosh.
Yeah, it was fun though. Yeah, I enjoyed it.
I'm
So,
glad it helped you somewhat.
definitely did. So thank you. And I would like to reserve 5 minutes for rebuttal, please.
Really need it. I mean,
I guess maybe
we
not,
watched the
but-
video.
Yes, yeah, so that is obviously a big part of the record. But I would submit that the problem here is that the trial court appeared to rely exclusively on the video. While it is very telling, the video does show us a lot, obviously, about the accident. The mechanics of the accident are pretty simple here. There's only 2 cars involved, unlike the prior case, so it's pretty simple facts here. That wasn't the only evidence that was submitted in the motion for summary disposition, so the trial court really should have considered all of the evidence together and how it plays off of each other. There were excerpts from the police report that contain a statement from plaintiff saying that he didn't see this large garbage truck before he hit it. There was also an
Well,
expert.
what about the fact that he said he was distracted while he was driving?
So
That seems to really hurt you.
it hurts us
Hurts the
that
case.
plaintiff was distracted.
Wasn't it plaintiff? Oh, good.
Plaintiff, yeah, so the testimony was that plaintiff told Mr. Reed that plaintiff was distracted while he was
I
driving.
apologize.
Yeah,
Yes, I
yeah, so which
forgot.
actually helps us.
Right,
but
right. it does.
nonetheless, we didn't rely on that in the motion, but that evidence was before the court because plaintiff did attach that deposition testimony to their response.
What do you think is the best evidence to support your case here?
Well, the surveillance video would be the best
Okay.
evidence, but that is,
Was it the fact that others were able to avoid?
Yes, because I see plaintiff's point about, there are some facts that we don't get from the surveillance video, but the expert affidavit coupled with the fact that there are two cars that you can see that avoid hitting this truck either by maneuvering around it or having ample opportunity to safely stop behind it. And those cars were driving under the exact same conditions as plaintiff was, the same
You have an
road.
unreasonable risk that some people avoid, but not all do, and that still makes it unreasonable. I mean, 1 out of 4 cars hitting it seems that could be a problem.
So the issue here, Your Honor, is we're looking at plaintiff being more than 50% at fault. And so the fact that multiple people didn't hit this truck shows that plaintiff is extremely culpable here. Him not paying attention makes him more than 50% at fault for this accident. I mean, the video also shows the method in which Mr. Reed was using to back up onto that road. It does support, his testimony that he was moving slowly. He was stopping at certain points to allow other cars to pass him. Under the circumstances, that was pretty reasonable behavior. I mean, he started backing up more than 15 seconds before plaintiff, came and struck his vehicle. What plaintiff is essentially asking is for there to be no cars on the road whatsoever. And I think that is a bit of an unreasonable ask here. And so.
Well, does it matter that your client backed out into lanes of traffic?
That is a point that matters, Your Honor, but again, it just goes to the overall question of whether plaintiff is more than 50% at fault. It doesn't matter if defendant, the question isn't all or nothing. It isn't, is if defendant is negligent, that means that plaintiff can't be negligent. Like, that's not the question. That's before the court. It's if you're looking at the record as a whole and the inferences that can be made from it, is plaintiff more than 50% at fault? And we submit that he is. There is more than enough evidence to show that plaintiff had the last chance to avoid this accident, and he had more than enough time to do so. This was an extremely visible hazard to him, and he had ample opportunity to not even make an emergency stop, to just make a normal stop. Plaintiff had the duty.
He could have gone around it. He had 2 open lanes.
Right. He didn't even need to stop. You're right, Judge.
Right. He had an open lane to the one side, which is where I think those other cars were. And then he had a center lane that was also available if the truck got
Now,
there.
that's not fact finding though.
Well,
That's what I see on the video.
well, you're right, Your Honor. The video does clearly show that one car is in the right, eastbound lane, the same lane plaintiff is in, and it does go right around that truck with no problem whatsoever. So stopping was just one of the many options plaintiff had before him. The option he didn't have was striking the vehicle.
For me, it was I'm sorry, Judge.
No, go ahead.
It was the distraction.
Yeah, I think
if a plaintiff admits that I'm distracted and then you hit a garbage truck, not a little, not like, a little person like Judge Letica or something running around in a row in the dead of night in black, that seemed to me, to be quite telling.
Right. And the trial court seemed to ignore that evidence altogether. I mean,
Was there a hearsay issue with that evidence, as far as you know?
as far as I know,
Because I don't know how it's not an admission.
right, it's pretty basic, opposing party admission, being offered against that party. The trial court.
Was this Hathaway?
Yes. Yeah. So she made essentially one sentence finding, just saying that she was convinced that the video itself, or she was not convinced that the video itself establishes that plaintiff was more than 50% at fault, which is the problem here. Because again, just even ignoring that admission that plaintiff was distracted, the other evidence
But you had
does
the expert
support that.
affidavit that said that he had plenty of time to stop.
Right.
And there was no counter to that as in our prior case.
Right. He didn't even attempt to offer any explanation for why he didn't see the truck. And then coupled with the fact that he made no evasive maneuvers whatsoever makes it pretty clear that he wasn't paying attention to what was happening in front of him.
I mean, all joking aside, between obviously myself and Judge Letica go round and round on a few things, But I mean, you are asking this court to make what's tantamount to a factual determination, which is to assign fault to one party over another. So I mean, there does have, in my estimation, not that we aren't allowed to do that. It seems to me that the record has to be incredibly clear.
Right, which you're correct, Your Honor. Courts can make this determination when no reasonable minds could differ on the facts, which we submit is the case here.
Well, why don't we hear from sister counsel and she can tell us why you're full of it.
Thank you, Your Honor.
Good afternoon, Your Honor. Stephanie Arndt today on behalf of Appellee. I'm just gonna.
Good to see you again.
Good to see you. This is
Well, you didn't have to lie, but it's nice of you to.
No, I am. So can I tell you before we get started? This is my first oral argument under the auspice of my new firm.
Yeah.
So super excited. I'm sure you'll see me take a selfie later. I'm really excited for
The
that.
court officer only charges $10.
Oh, that's fine. I actually have cash today, so we're good because I have to pay for parking. Always get cash.
He
when you
accepts
come by.
cash or Subway sandwiches. Yes, either.
Okay, we'll do cash. It's all good. Just make sure the lighting's right. All right. So let's just jump to some of these issues because obviously I'm gonna have to dig myself out, it sounds like. So first of all, this whole issue of my client allegedly told the defendant that he was distracted. That was never part of their motion. Their motion, the only exhibits were the video and the Newton's affidavit. And it really, when you look at their motion and their arguments in the court or in the trial court, it was all the video. And I know you've seen the video. It's
Repeatedly.
Yeah.
I'm glad for you. It's I mean, literally the accident happens under the timestamp. It's extremely pixelated. This whole, you look at Van Newton's affidavit, he's like, well, it didn't appear that it swerved. It didn't appear that it went down. It's so pixelated. I don't know how any of that happens or is visible. And then as I pointed out in the response, also, there's no indication that this is what Mr. Harper saw because it's from across the street. I don't know if it's backlit.
I see a giant garbage truck with blinking lights on it.
Well, interestingly enough, no one attached his deposition, so it's not part of the record. So what we have is the fact that he struck the truck and the truck admitted,
Like it wasn't even there.
the truck driver admitted that it is his responsibility to make sure that it is clear before he backs out.
Okay, so the right-of-way violation, you got me there, but we're talking about who's more at fault.
Okay, and so interesting thing that you point that out, because obviously that's why we are here. But as I'm getting ready for oral argument, and obviously too, while I'm briefing this case, I'm looking at these cases, trying to figure out, what is the formula? Like, when do we know something is 51% fault? Because again, we're not engaging in fact finding. And if you look at the case law, especially the current case law that's even come out since this appeal, since all the briefing was submitted, if you have a situation of shared fault, and if there is conflicting evidence, the court has been very clear, both this court and the Supreme Court as early as June of this year, those go to the jury. And what do we have here? We have the potential for shared fault, and we have conflicting evidence. So McDuffie versus Neal, that was a Supreme Court decision, June 11th of this year. There was a video involved in that case also.
Can I interrupt you real quick? Do you have a case number on that by chance?
On McDuffie, I have the case, yeah.
It might have been nice to file supplemental authority.
Yes, yes, I agree with you, Your Honor. And honestly, I actually thought about it, but let me clarify though, because I actually do file supplements a lot. They didn't change the law. This is just an example of another situation. And so that's why I didn't file the supplement, because it wasn't actually a modification of the law. It's just a continued application. So the docket number is 166865.
Can I read it back to you, please?
Yes,
166865.
yes.
Thank you very much.
Okay, so so McDuffie versus Neal, that was Supreme Court, June 11th, 25. That involved a video. Supreme Court said that is a question of fact for the trier of fact. Then we have this court, September, Pulduck, Pudelek, which is docket number 369616. Again, summary disposition properly denied on the issue of plaintiff's negligence. Then we have Judge Ackerman's recent decision, White versus Pace, 371878. Comparative fault was an issue for the jury. That was published. And then, what's today? The 9th, 4 days ago.
You know, we also have, I wrote another one, Roland v. City of Detroit, which had a video where we actually, you know, there's a similar contributory negligence about someone opening a door into traffic, and we had a video. The bus was in its lane, someone opened a door into traffic, and no reasonable person could conclude that the bus was more at fault than the person. So we you know, I think there's a lot of nuance there.
No, and I agree. And
Yeah.
this is all for example purposes, and just the sheer fact that defendant stands here asking you to find as a matter of law more than 51%. And when you look at the way that the law has been applied, even very recently, since these briefs were all submitted in May, the difference is that we let juries do their job. Yes, here, there are some issues with the way that Mr. Harper was driving his vehicle, but there's also issues with how this truck was backing out, the fact that it did not adhere to the right-of-way, the fact that the driver admitted he never saw Mr. Harper, the fact that the driver admitted that he was to be maintaining a careful lookout and that he was to be making sure that the road was clear when he backed out. Apart from right away, that's just his own admissions. He's supposed to be doing these things and he didn't. And so then we get into one of these at the risk of looking like a 6-7 YouTube video. We do this. When we do this, then we let jurors do their job. And that is what Judge Hathaway did. Yes, she left her comments to the video. She said the video is the video, and it's nice that we have a video, but I don't think it's dispositive. And I think that that's true. And on this whole issue of video, I just want to make 2 comments. The Sixth Circuit just did a really nice opinion. It's called Nash versus Bryce, Sixth Circuit docket number 24-1263, September of 25. In the opinion, obviously it's a 1983 case, nothing factually analogous.
It's not binding on us.
It's
because
not,
an
but
intermediate level court in the federal side.
I agree with you, Your Honor, but they raised Scott versus Harris, which is the U.S. Supreme Court decision on the admissibility of videos and how we watch videos. And what Nash versus Bryce reminds everyone is that when you watch a video, you don't, as a judge looking at a dispositive motion, you don't watch the video to confirm if it says what the defendant said it says. You watch a video to see if it's dispositive of the issue or if it's blatantly contradicted. If it's not, if it leaves things open, like the video here does, then we don't just say videos are the be-all, end-all. And Judge Borrello, you made a comment in one of your dissenting opinions. This case demonstrates the unremarkable proposition that the mere fact that an incident is captured on video does not place any conclusion about liability beyond dispute. That's the situation here. Yes, we have a video. We have a video of the accident over numbers, very pixelated, difficult to see any kind of nuance level. We also have testimony.
Video, it's not pixelated, at least not my version, so.
We also have testimony that goes both ways and establishes potential for a finding of shared fault. In that situation, the trial court was correct in denying summary disposition because the only person who can decide an issue of shared fault is a trier of fact.
So your contention, as I understand it, is you're not disputing that there's contributory negligence here. Your issue, not whole, but the genesis of the argument is that doesn't mean that my client was 50% or more than 50% at fault. Nor does it give you as a judge to usurp the role of a juror in such cases. Provided that my client produced some evidence that fault lies with both parties, then it's up to a jury. And I'm kind of broad strokes here, but that's essentially where I hear your argument. Would I be correct or?
Yes, broad strokes and without the words contributory negligence, because those terrify
That's true.
me.
I
If
get
you-
it.
if
I'm
you can
66.
rephrase
That's
it-
how I learned.
If you can rephrase it with my contention is, yes, my client, a jury could find him potentially at fault. The issue in this case for this appeal is this is not a situation of judicial fact finding of 51+% fault. This is a situation of shared fault, potentially conflicting evidence. This is why we have juries, and a jury needs to decide the allocation of fault in this case.
Let me ask one last question, if I might. Should it matter, or can it even matter, that in this case, we already have one judicial finding that states that I don't think this person's 51 or more than 50% at fault? Should I put any credence on other than, what I'm obligated to do under relevant standards of review?
I think you should give some credence to it, but I respect that it's a de novo review by this court. But I think that you should give some credence to it, yes. Any other questions? Thank you very much.
So I have to ask, I did not know you had left the firm. How long has this been that you've been on your own?
Since May.
Wow.
Yeah, super
That's a
excited.
gutsy move. Congratulations. I
Thank
hope
you.
it turns out well for you.
The middle of every month is sheer terror, but other than that, it's great.
That's why I'm here now.
I know, because it's always like, am I going to have enough to pay the bills next month? But other than that, it's amazing. And I get the opportunity now to work on great cases all over the state. So
Awesome.
It's super
Well,
exciting.
congratulations
Thank
to
you.
Well, she told us why you're wrong. Now you get to
I
tell
know.
us finally why she's wrong.
I know, unfortunately, I have to be back up here again. So I'll be very brief. So a lot of what Sister Counsel said relied on the fact that there was potentially conflicting evidence, yet she did not point to what evidence was conflicting. And I don't believe there is any conflicting evidence here. Plaintiff certainly didn't present any in response to defendant's motion. And as Your Honor pointed out, we have plaintiff's own admission that he was distracted, coupled with his admission to the
Would
police.
that admission, I mean, can't just take that completely as fact. He has some self-interest in saying I wasn't at fault. He said he was distracted, right?
Well, I mean,
I think maybe there are other things consistent with it, but I just don't, I want to be careful not to just accept that.
right, Your Honor. So we do need to view the evidence as a whole, and there are other pieces of evidence that are consistent with that statement, because plaintiff did say the same thing essentially to the police. He did say that he did not see the truck. So that is consistent more or less with the
With your
statement.
expert who
Correct.
clarified that you could have for several seconds.
Correct.
Was the deposition included in the record? I mean,
It was
any response to that?
attached. It was attached to plaintiff's response. So the court did have that evidence before it when it made its decision. And then to the extent that Sister Counsel is relying on new cases, we would like the opportunity to have supplemental briefing if the court thinks that would be helpful. But again, it does sound like a lot of the courts have found it to be a fact question when there is conflicting evidence, which isn't the case here. Thank you.
So why didn't you argue this case? I'm telling, she's one of my jury committee buddies.
Yeah.
Gosh, that's a fascinating committee, isn't it?
Yeah,
Yeah.
it really is.
Uh-huh.
And I like it because every period, every comma, everything matters to try to find out, like, so.
Oh, really?
Yeah.
I missed the last one. I hope I didn't miss it. I was actually doing a contempt proceeding, but anyway. Yeah. Not against you. And nobody bid anybody.
Civil.
Well, good to see you.
All right.
Thank you. Excellent arguments. Appreciate it.
The matter has now been submitted. We will now call item number 10, docket number 374958, Welling v. Welling.
Sorry we made you wait, Mr. Gentry.
Yeah.
No problem, Your Honors. I was going to say that it's after one of my iPads at 7%, so I will keep it brief.
Oh, boy.
So, Your Honors, the UCCJEA case, I'm not going to do what I shouldn't do, and that is address the non-record evidence that appellee dumped onto this court, unless Your Honors want me to. I would love me to. But no, on what the trial court had before it, the trial court had to do a couple things. One small thing, but it didn't follow section 1110 recording the judicial conference. It would just be nice if somebody mentions that to remind the trial court, because it didn't. But the much bigger thing, the 1207-2.
Can I stop you?
Sure.
Just because I think that is an important point. And candidly, you know a lot more about this area of the law than probably any of us. Is it permissible for the court to overlook that and for this court to then still make a finding that it's harmless error? Or is it your opinion that unless the court specifically adheres to that verbiage, that there's error?
Yeah, and I think there's error because the statute says it makes a record, and the purpose of a record is to allow the parties and eventually this court to know what in the world happened between these two judges.
Right.
And the statute gives a specific exception. You don't have to do a record for case call, conference scheduling, stuff like that. But when you hit the merits, how is this court going to know what they talked about?
Right.
It's not. The legislature made that for a reason, and it's a uniform act. Of course, they made it for a reason. It's a uniform act all over everywhere. And the error wasn't just here. The error was in Utah too. When we get to the 1207 Cheeseman, this is a Cheeseman case. It's really a Cheeseman case. And there's not a whole lot of ways around that. The statute says shall. We know in child custody when the statute says shall factors, and you all see it far too often. Factor A, factor B, factor C, factor 1, factor 2, factor 3. Is it rote, tedious, and boring? It can be. Is it required by the law? Absolutely. And is there a reason for it? Absolutely. Because if you're going to consider where there's uncontested evidence that Michigan is a home state, you're going to consider Michigan an inconvenient forum. The legislature and the Uniform Act says you have to look at these things. And the judge didn't look at all of them. He made some offhand comments about a couple of them, didn't make actual findings on any of them. That's a real problem. That's a real problem here. Your Honors, we're taking this record, I hope, having heard all of the discussion about appellate fact finding, we're taking this record on what it was before the judge when he made his decision. Under Foster, if he got it dead wrong, Your Honors can say that it's dead wrong and say that this case belongs in Utah. I'm sorry, in Michigan, which is the home state of the children. It doesn't belong in Utah because it's not a convenient forum and because that's an exception to the general rule of home state. And this case belongs in Michigan, and under Foster's, Your Honors can make that determination. The court has held that, and it should in this case, and quite frankly, give the decision immediate effect because this has gone on far too long. Thank you, Your Honors.
Thank you.
Thank you.
Good afternoon, Your Honors. Attorney Andrew Babnick on behalf of Jessica Welling, the appellee. Your Honors, I agree that this is a Cheeseman case, but the court did find that Michigan had jurisdiction, that Michigan was the home state, and then went through the analysis as it's required under section MCL 722.112 or 1201, I'm sorry, and made factual findings. Unlike in Cheeseman, where the court simply said jurisdiction is inappropriate, it needs to be somewhere else, the court went through and made in its opinion, outlining what each one of the factors were, citing to the statute directly, and then a paragraph with each of the factors as it found the facts relevant to it. So this court is reviewing this, not de novo, but for an abuse of discretion here, which again, the trial court heard the facts. The trial court did make a finding of facts contained within its order. And as I outlined in my brief, while the trial court did not delineate it the same way that we would see typically in our cases related to best interest factors, placing subsection A, and here are the facts, subsection B, it complied with Cheeseman by making findings of fact. And it did find that based on everything that had gone on in this case, and based on the history and the fact that the parties had, Utah had jurisdiction, and I want to make clear to this court, at no point has Utah's jurisdiction been challenged in Utah. The case continues to proceed as it exists there today. The parties are in that case, well advanced into that case now a year and a half later. The children are there, the children are in school there, the parties reside there, there are pending criminal matters there, pending DV cases there, which is what the court has put forth in its order. So I do strongly believe that the court did, under Cheeseman, do what it needed to do, and it needs to be reviewed. We have a battle here, obviously, on the standard of review. I don't believe this is a de novo review, but an abuse of discretion based specifically on the findings in Cheeseman that, and Nash v. Salter is cited, in my opinion.
What about the fact that, of what I asked brother counsel about, which is the fact that neither court communicated what they were talking about? Do you think that's relevant, number one? And number two, does it have any effect on the ultimate decision here?
Your Honor, if you look to the footnote in my brief, the court did on the January 31st hearing indicate on the record that it had the conversation with the judge in Utah. I'm misstating the word because I believe it's a magistrate in Utah, and that they had a conversation related to whether there was jurisdiction, and that the magistrate in Utah had indicated that there were concerns that she wasn't sure if Utah properly had jurisdiction. So they made a record related to that both parties were privy to. I don't disagree with counsel that there should be maybe a memo done in compliance with the statute, but I do think it's harmless error in the sense that neither party was prejudiced from it. Neither party participated in it. Both parties had the opportunity with Michigan counsel to be before Judge Farhat and to present and do the fact finding that's required. An evidentiary hearing is not needed, and the statute is very clear on that. Judge Farhat heard the facts, and his initial opinion at the onset of this case, per the record, was that he thought this case would go back to Utah until the facts were presented to him. The purpose of the UCCJEA is to prevent forum shopping, but to also provide victims with domestic violence an ability to be sheltered, which is what occurred here. Utah has jurisdiction. Utah.
Temporary emergency jurisdiction.
Correct, Your Honor, but then that gives the court here, and I'm not arguing, and nor did I argue then, that Michigan is the home state of the child at the time of the file.
I understand.
So I think the court made the proper determination as it related to the more convenient form, given the fact that the case had progressed, given all of the factors related to 722-1201, which I won't repeat here. I outlined them in my brief and cited to the portions of the judge's record and his findings as to those facts. I do believe that this should be upheld as a result, and that Utah should continue to hear this matter as it progresses.
Questions? Thank you.
Thank you, Your Honor.
Honors, I'm going to burn about 2 minutes here, and I apologize, but it is a statutory question, which is de novo, and it's a bigger question than that. Do we kind of sort of apply with statutes? We don't kind of sort of apply with statutes.
Not an application of facts to law, though. Right?
It is an application of facts to law. However, the statute says that you've got to make certain findings. The statute says it has to be on the record, not a memo afterwards, not a finding out by the court that I had this conversation. The statute expects to be strictly complied with. The whole purpose of the UCCJEA is to make this then uniform, and that's not what's happening in this particular courtroom. Not in this case, and that's very unfortunate because it's made a hash of everything. When we look at what the judge said certain things that were relevant to certain findings required by the statute. Didn't hit all of them, not even close. And I would read it, but my iPad has ran out of gas.
Well,
And I don't think I need to read them because I think your honors have.
we have read them, and maybe a couple, like how far is Utah from Michigan, but I don't think it has to be an A, B, C, D, E. He hit a lot of them, if not almost all of them.
And I guess we're back to where I was. Can you kind of sort of comply with the statute? And I don't think you can. I'm going to take issue with the idea that my client is a domestic abuser. There was never a finding of that in Utah. He'll be mad at me if I don't say that. There wasn't. It would be the protective order was dismissed by stipulation. Your Honor.
Because they started the divorce action there, right? And then agreed to a.
Your Honor, all this happened well after the record. I can go into great detail about why I've got docket entries and all sorts of things.
Okay.
But is that what we do? Is that really what we do? I mean, it's very bad for the child. And yes, this case does bite, that the child has been that long in limbo. But nothing's going on in Utah with this case. It is dogged out. And because of this, the parties stipulated that divorce would be in Utah, but stipulated only the temporary emergency jurisdiction in Utah. So the case is still at the initial stages of child custody, sadly enough. And something needs to be done about that. Obviously, this court needs to resolve it. But if we're going to comply with the statute, we really ought to comply with it. Thank you, Your Honors.
Thank you.
Thank you. The matter has now been submitted. Move on to our final argued case of the day with the item number 11, docket number 375163, Mead v. Rowe. I believe Collins Counsel is remote. Yeah.
Good afternoon, Your Honors. Can you hear me at this time?
Yes.
Okay, great. Are you ready for me to proceed?
Yeah, whenever you're ready.
Great. Sometimes when I get switched over to panelist, I lose track of exactly where you are.
It's tougher on Zoom than it is in person to be as obvious. I should have clarified. So anyway,
Certainly.
thank you.
Not a problem. And I promise there's no biting in this one. Lisa Schmidt appearing on behalf of appellant Taylor Mead. Your Honors, this is a significantly more straightforward case than the one I spoke to you about earlier today. The question here is whether the trial court should have been applying Vodvarka or shade. There's no question that the appellee had the right to seek a specific parenting time schedule according to the judgment and according to the change of circumstances in the interim, that being the absences at the school, the fact that there had been some disagreement over the school enrollment. But there's nothing here that amounts to anything more than everyday normal life changes. We don't get to custody, and the trial court did. The trial court removed mother's primary physical custody as awarded in the judgment of judgment of support, and made it equal custody based on what father represented was a 4-3 split. In fact, the record never demonstrated more than he exercised essentially weekends and a couple full weeks during summer vacation when he took the child up north. Your Honors, in making the decision based on this de facto legal or physical custody, which is the language that father used, the court inverted the burden of proof. It required the mother to demonstrate by clear and convincing evidence that the order as it was written should stay in place, rather than requiring the father to prove that it should change. This is clear legal error, and it was admitted in appellee's brief that he was supposed to have the burden of proof. So that in itself is reversible error. I would just also like to clarify one thing that was not in my brief, and then I will just take any questions because I know we've all been here a long time this morning. Nothing in the Child Custody Act allows the parents to unilaterally decide what's in the best interests of the children. Even when the parties come to a consent judgment under Harvey versus Harvey, we still need the trial court to make findings regarding the best interests. That means that even that de facto joint arrangement of 4-3 was not enforceable by the court because nobody asked the court to enter an order in that regard back when they were exercising it. Then the child gets burned, the situation changes, and dad comes to court. He's allowed to do that for parenting time, but that should not have been a basis to change custody.
Any questions?
No.
Well, thank you very much.
I told you that one was straightforward.
That was straight. That was short. I don't
Good afternoon, Your Honors.
appreciate it.
I think this is a straightforward case as well. However, I do think that the trial court was pretty thoughtful in its written argument or written opinion. When the court is looking at established custodial environment, it is required not only to look at the order that was in place, but also to look at the specific facts of this case. And in the initial motion, the judge did indicate when that was being argued that there was an issue of fact when it came to how many overnights the parties were exercising.
there wasn't an exact arrangement. The parties had been very flexible. They'd gotten along. This case started during COVID, so there really wasn't any reason for them to come back and modify or get a formal order in place because they were getting along. The appellant continues to utilize this burn incident as a reason for changing the custody. However, I believe even in the record, it reflects that the burn incident isn't what changed parenting time to go to every other weekend. That actually didn't happen until the fall of 2024, right before my client filed that motion. The court is also correct in applying or indicating that by a preponderance of the evidence that at least one of the child best interest factors is needed in order to then review or modify custody. And in this case, the child had missed a significant amount of school for 2 school years, and the parent, the appellant mother, unilaterally changed schools even after she asked my client, asked Mr. Rowe, the father, and he clearly indicated no.
And in this case, didn't the record also reveal that when mother changed schools, she failed to list your client as a contact?
She did. And in fact, in the record, she said, well, he's an adult. He can go himself and do it, which he took the initiative to do. He took the initiative to contact the teachers and make sure that he was involved in this child's life, despite appellant mother really doing anything she could to try to stifle that. I mean, prior to the change in schools, my client, Mr. Rowe, did testify that he was able to take her to school or pick her up from school some of the time because they were in district. In fact, the mother's home was less than a mile from the original school, and she still couldn't get her to school on time. So
Can
then
you refresh my memory, counsel, as to why mother made this? I don't recall the basis for the change. Did she claim it was a better district, or?
she claimed the child was having behavioral issues and she had a better support
Okay,
system in the
that's
other
right, that's
school,
right,
but
yeah.
that was really it. And my client, and in the evidence that we supported or that we presented at trial, supported the fact that this was a 30-minute drive for my client when it was only, a few minute drive before, and that would really inhibit his ability to really take his child to and from school. I think even if the higher burden of proof was applied in this case, the court was really generous in applying those best interest factors equally among both parties. I mean, Judge Olsaver indicated that each factor was weighed equally, despite the fact that appellant mother failed to include my client on any school information, purposefully changed schools without his consent, and then reverted to every other weekend schedule with no wiggle room because she was mad at him for whatever reason. And that's really not in the best interest of this child. At trial, we had a parent who's clearly committed to and desperately wanting to spend more time with his child. Again, he admittedly mistakenly believed that all times agreeable meant if we agree on it and keep the courts out of it, then we don't have to worry about a set schedule. And again, they largely did a good job with that up until October of 2024. But again, I believe the judge was generous in equally factoring those favors for both parties. I think that there could have been a couple of factors that weighed in favor of my client. However, even if the higher standard of proof is applied here at clear and convincing evidence, I think that the court still would have arrived at the same decision and in increasing my client's parenting time significantly. And that can only benefit this child as she now has the ability to spend as much time with her sister on her dad's side as she does on her sister with her mom's side. She gets to enjoy having both parents equally involved in her life, and that truly is in her best interest. Your Honor, again, I do think that the facts support. The judge was clear, and I think he was accurate in his written opinion. I will rely upon that as well as my brief. But again, I would request if the court does remand, that it just remand and believes that a different burden should be applied, that's what the court do. But I do think in this instance that the trial court should be affirmed. Thank you.
Thank you for your patience. I've seen you sitting back there all.
I missed my daughter's Christmas performance this afternoon for this, or holiday performance. So, well, we're going to miss it, but my husband's going to record it for us.
Sorry to hear that.
That's okay. This is my first time before the appellate court, and I'm not going to lie, hopefully the last. This is not my favorite thing to do. However, my client and I found it important to hopefully be able to advocate
Well, I'm
for him.
sorry I screamed at you.
It's okay. It was quite entertaining. So, it could have been a worse experience, but I really appreciate all your time.
Can I ask a question? And as you, as you noted, we have many family law cases today, and you said for whatever reason, isn't this the case where there was a post on Facebook that was critical of mother?
I don't believe so. Yeah.
By the the mother of the.
I think there may have been a text, they texted each other and there was some dispute, like because the stepmother and the appellant mother did largely communicate beforehand.
That's the text. I remember it. Yeah.
Yes.
Okay. Okay.
Thank you.
Thank you.
All right, we have time for a brief rebuttal.
Yeah. Sister counsel is correct. It wasn't on Facebook, but they did get a little heated during the text exchanges, and that was a significant aspect of the breakdown of their co-parenting relationship.
It did not aid the cooperative relationship. Let us just say that.
That's a great way to put that. As another factual clarification, Your Honors, the transcript reveals that mother did list father as a contact with the school, but did not at that time have his address. And that was the comment of he's an adult, he could have added it. It was, they didn't have the full contact information for him. So it's not great. She could have done her research, but she did list him as a parent for the school.
Your client's an adult too, right? So she could have done it.
She could have done it. Absolutely. I'm not disagreeing with that, but I would point out, Your Honor, that if they've got joint legal custody, that means both of them have the same responsibilities to the school and to the courts.
I'm just going to say I disagree with you because the father, or excuse me, father didn't switch schools. Your client did, so it became her responsibility, not his.
I can see that, Your Honor, and like I say, she did provide his identity, just not his address. I would just point out, Your Honors, that we do have case law that is cited in my brief. Corporan says that school difficulties are insufficient to modify custody, and also a violation of a custody and parenting time order is not sufficient to modify custody. And that one is Kaiser and Adams. So to the extent that sister counsel is saying, well, we clearly had a reason to modify custody because of these issues, those issues are explicitly not sufficient to upend the custodial arrangement. And it's important for me to say, appellant was not seeking to change custody. Appellant was awarded custody. Appellee was seeking to modify custody. That's all I have.
Thank you very much. And with that, the matter has now been submitted. I'll call our final item for the day. There are no endorsed parties. Item number 12, docket number 374088. Carol v. Olger. That matter has now been submitted. And with that, we are done for the day.